Come to order and start where we left off. We're starting Division 8, Clause 192, and BQ 6 is the amendment, and it is inadmissible. It's contrary to the principle of the bill as established at second reading, and so it is inadmissible, BQ 6. You can still let it. But you can speak to it. We will not deal with it as an amendment, but you do have the right to speak to your amendment, but we won't consider it.
Okay,
so if you want to make your point, go ahead.
Okay, I have the right to explain it.
Yeah.
Okay, bon. Bien, bonjour, en fait.
Good morning. The proposed amendment is that at clause 192, line 9, page 110, be changed with the following year, $300 million. And the reasoning behind this is that what one must understand is that this amendment seeks to change the analysis sum from $600 million to $1 billion. For us, that is a bad idea because the Investment Canada Act means that the Economic Development Minister must study foreign investments that go beyond a certain sum. And when he studies this, or she studies this, they have to analyze whether or not this is a good analysis. It's a net advantage analysis. It also gives them the power to say yes or no to the transaction or to impose conditions. To us, 300 million rather than 1 billion would be much more interesting as a value because most Quebec companies, large Quebec companies, very seldom go beyond $1 billion. Perhaps you can count this on 1.5 hands. That was the sum that was put forth when the bill was first adopted, and that was what was negotiated with NAFTA. We believe that below 300 million could be acceptable. We believe that 300 million is a reasonable amount, and that is why we have proposed this sum. This would be for companies that are bought abroad. Rona, for example. The Rona case went beyond $1 billion, but Can-Am was bought for under $1 billion by American interests. And so when there's a sum that goes beyond that sum for national reasons, the minister can decide whether or not this is good or not and can impose conditions. Having a lower bar would be better for us and better for the economy of Quebecers and Canadians.
Deval, there is witnesses here from related to Division 8 as well, Mr. DeWolf and Ms. Brady. If anybody's got any questions for those people as well. But the reason that the motion is out of order, the bill aims to, the principle of the bill is it aims to increase the threshold from the current 600 million, decreasing the threshold to 300 million, contrary to the intention of the bill to increase it from its current level, and so that's why it's denied. Any further? We will not deal with the bill. It's out of order. But is there any question to Ms. Brady or Mr. DeWolf?
And just a very quick one. I was just wondering, for Ms. Brady or Mr. DeWolf, I was just wondering what the process was that led to the decision here. So how did you come up with that decision? And that's essentially it, yeah.
Sure. So there is already a schedule in the Investment Canada Act for the threshold to rise. Gradually, it started in 2009 and rose to 400 million, then 600 million, then 800 million, and then was intended to go to $1 billion in 2 years from now. So this amendment would accelerate that already planned increase by 2 years.
Thank you.
There was a committee, I believe, there was a committee that made recommendations.
That's right. Yes. The Competition Policy Review Panel in 2009 made recommendations to raise the threshold to $1 billion.
And one final question: who comprises that committee?
the Competition Policy Review Panel.
Yes.
It was led by Red Wilson, and the precise membership escapes me now. There were a number of lawyers, business people in Canada, prominent business people and lawyers primarily, but Red Wilson was the chair of the panel.
Did you have a question, Mr. Dussault?
C'est plus un commentaire pour...
More of a comment to thank my Bloc Québécois colleague for this amendment that is deemed inadmissible because it goes against the intention to increase the threshold. What I propose is to vote against Clause 192 in general, so that the $1 billion increase does not happen today, but would rather follow the calendar that has already been provided for. It'll still be an issue, but at least the increase would not come today. I invite my colleagues to vote against Clause 192.
Okay, any further discussion? Then BQ6 is disallowed. Shall Clause 192 carry? On division? On division. There's no amendments from clauses 193 to 234. Does anybody have any they want to pull up, or are we okay? I'll give you a few moments to have a look at that. 193 to 234. The agendas are being distributed now. They had to be reprinted. You okay? You all okay? So on the amend clauses 193 to 234, do they carry on division? Carried on division. 235. Thank you, folks. 235. We're into Division 11, support for families, benefits, and leaves. NDP 16. Mr. Dussault.
Merci, Monsieur le Président, et cet amendement.
Thank you, Chair. This amendment has to do with changes for parental benefits in EI that is provided for in C44, like our witnesses explained to us. I would like to welcome our witnesses. Like they explained, the changes mean that we can now take longer maternity or parental leave, rather, with the same sum of benefits. That means that over 16 months, or 18 rather, it goes from 12 to 18 if I remember rightly, rather than receiving 55% of one's salary, which is already rather low in my opinion, in our opinion as the NDP, it would go down to 33% of one's salary for a longer time period. I do not believe that this is a positive. That being said, to respect the intention of the legislator, my amendment seeks to make the decision revocable. That is what my amendment number 16 is trying to do. It's a rather short one. I can read it. An election made under subsection 1.1 or 152.05 1.1 may be revoked by a major attachment claimant or individual, as the case may be, and a new election made, etc. And so, if personal situations change and if the beneficiary can come back to work more rapidly, they can do so and will still obtain the same amount. That is equivalent to 55% over 12 months, but over a shorter period of time. If conditions allow, if this person can go back to the workplace, I asked the question to figure out whether it would be possible. No one denied its feasibility. Perhaps it might be more complex administratively, of course, but I believe that the difficulty of this is not a major issue because we're trying to make the system more flexible for beneficiaries, and I believe that we can absorb a certain number of complexity when we want to serve Canadians in all kinds of situations that may be different from one person to the next. That is what my amendment seeks to do. I hope to receive the support of my colleagues so that this imperfect measure is made slightly better with a bit more flexibility, as my amendment seeks to reach.
Mr. Dussault, I'll remind folks as well that there is, if there's question to any of the witnesses here, they're here on this Division 11 from Employment and Social Development Canada. Is there any further discussion on this point? Mr. Ouellette.
At first view, actually, this measure seems pretty interesting because it gives a lot of flexibility to an individual claimant. For instance, if you had two parents and they had the opportunity then to decide who would like to take the parental leave, and one says, well, I'll take it for 2 weeks now, I have a contract that's coming up, and then the father can take a long period, and then they can switch again when there's contracts change. I guess in Service Canada's opinion, what are some of the reasons that you might give that this would cause issues? And do you have any costing on this as well?
Great, thank you. So I think that one of the things that I would speak to really was that in the consultations, it's not only from the perspective of administering the program for us, it is thinking about employers as well who need to be able to deal with the leave and potentially top-ups to the EI benefits. And so if people were changing their selection of the duration of the leave and also the payment rate, whether the lower 33% or the higher 55%, it could result in incorrect payments to claimants that we would subsequently have to recover, as well as challenges for their employers in dealing with both the leave and any top-ups that they need to provide to those employees.
Mr. Ouellette.
Very quick question. Are your computer systems, your software, able to handle something like that?
They're certainly not able to handle that at present. There will be work underway in order to implement changes to the system so that they will be able to cope with what is proposed. This proposal here, in terms of allowing the parents flexibility to select the option up until the time that benefits are paid, would align with the same approach that's been taken in Quebec with the Quebec Parental Insurance Plan.
And then, so I also want to just delve into the issue with the employer. If you had, and sorry to my colleagues, this is just a very interesting line of thought, flexibility for people in their lives, because lives are not always uniform. We always don't have 9-to-5 jobs. Is there provisions in the law that force employers to accept someone's parental leave? So if someone applies for parental leave and they say, I'm taking 36 weeks, the employer is obliged to give them the 36 weeks?
Yeah, the employee is entitled to take the leave anytime he wants. So if he specified the date 4 weeks in advance, he's entitled to take the leave on that particular date.
The leave provisions, though, vary across the country based on the province or territory, or whether the employees are regulated by the Canada Labour Code. And so at this point, it remains to be seen how provinces and territories would intend to follow or not the federal government's lead in terms of changes to EI benefits.
Now, you mentioned Quebec as well. Quebec, I believe, their parental leave plan also allows more people to participate, meaning, for instance, if you're self-employed, you're able to pay into the plan in order to receive greater level of benefits. And in fact, there's actually an increased cost, but they've also seen an increase in the number of males taking parental leave to look after their children, and they're far above, perhaps more feminist. They're more, than some other. Anyways, it seems to be more encouraged. Why were some things like that? Like this measure would obviously increase the level of flexibility, but there's a lot of self-employed employees that could possibly use that to their benefit.
So there's a number of differences between certainly the EI maternity and parental benefits program and the Quebec Parental Insurance Plan. With respect to self-employed workers, it is possible for self-employed workers in the rest of Canada to opt into the EI program to pay premiums and obtain access to maternity and parental benefits. So that's existed now for about 6 years, but the participation is very low. Whereas in Quebec, it is mandatory participation, including self-employed. In terms of other aspects of the program, it's true that in the Quebec program there are dedicated paternity benefits, which I would say are intended to encourage men as well to take parental leave. And indeed, in Quebec, we see many more men taking advantage of the paternity and parental benefits proportionally than we do in the rest of Canada, which does not have a dedicated paternity benefit.
Okay, any further questions or discussion on NDP 16? Shall the amendment carry? All those in favour? Opposed? Lost. Yep. Shall clause 235 carry? On division? On division. BQ7, Ms. Pause. I'll say. Sorry.
Alors, bonjour, Monsieur le Président.
44, the government amends EI for parental leave and seeks to increase the number of weeks during which a woman can receive maternity benefits. That's excellent. It is recognised that a better integration of women in the economy has positive effects on Canada's economic vitality generally. That's the good news. The not so good news, and believe it or not, Mr. Chair, is that a mother who loses her job during her leave or immediately afterwards does not have a right to obtain EI, and therefore there's a significant problem for mothers who use their maternity or parental leave to receive their EI benefits once they lose their job. This difficulty already exists in Quebec, and we have notified the Minister of this numerous times. Nothing tangible has been done, and it is for that reason that I'm here today. Our amendment would allow us to fill this shortcoming in the bill. If we look at this in a more detailed way, currently to determine whether someone is eligible to EI, the government examines the number of hours worked over the past year, but by extending the number of weeks before receiving the benefits, Canadian women will experience what Quebec women have been living through recently. If they lose their job during their maternity or parental leave, they will be excluded from EI admissibility because they will not have had accumulated the required number of hours to be admissible. And so, if we do not remediate this situation, Bill C-44, which tries to be virtuous on that front, gives a right to women, but does not grant the right to women who lose their jobs during their maternity leave. They will be penalised. They will have one fewer right. I believe that this government that claims to be feminist should seek to protect those that are at the mercy of the whims of a job. When you lose a job is already difficult enough, so imagine a single mother who loses her job and has no revenue. Stated otherwise, it is scandalous that women who lose their job do not have a revenue simply because they had a child. This is indirect discrimination against women, and we believe that the government must remediate this. To conclude, Mr. Chair, what I fear is that you might say that this amendment increases the scope of the bill and therefore is irreceivable, inadmissible. I will not be able to argue because I'm not part of an official party. If that is your decision, I would ask for someone else to appeal your decision, because no, this amendment does not increase the scope of the bill. No, this bill does not change the nature of the benefit. No, it's not a new benefit in and of itself. The amendment that we're proposing seeks to specify the nature of this new benefit that C-44 seeks to instate. We're simply adding a definition. Indeed, we can go even beyond 52 weeks for retirement or for compassionate leave or medical leave. In that case, the government does accept an exemption, but it's not the case for parental leave. And so our amendment has one single objective. It is to protect women and children when a mother loses her job. Thank you, Chair.
Thank you, Madam Passe. And yes, you are correct. I will rule that the amendment is inadmissible, and I'll explain why. Bill C-44 seeks to amend the Employment Insurance Act to increase flexibility in the provisions of caregiving and parental benefits. The amendment would result in higher benefits being claimed beyond which the bill provides for. As House Commons Procedure and Practice, second edition states on page 767 and 768, quote, since an amendment may not infringe upon the financial initiative of the Crown, it is inadmissible if it imposes a charge on the public treasury or if it extends the objects or purposes or relaxes the conditions and qualifications specified in the royal recommendation, end quote. Therefore, in my opinion, the amendment would extend the charge on the public treasury. Therefore, the amendment is inadmissible. And that was a new clause 235(1), so we do not need to deal with that. Coming then to amendments to clauses 236 to 244. There is no amendments on those clauses. Is there consent to deal with them all as a block? 236 to 244. We're okay. Carried on division. 236 to 234. Carried on division. On clause 245, NDP Amendment 17.
Monsieur le Président,
Thank you, Chair. I won't be spending too much time on this amendment, which is similar to NDP 16. But if we are looking at self-employed people, we want to give them the same flexibility than that which I proposed earlier, but that was rejected, so I fear that we will have the same outcome. We want there to be more uniformity with other beneficiaries for self-employed people, and we want them to have more flexibility that my proposal could grant them. We could change our idea on this to have the same amount of money at the end of the day, but that is spread over a different period of time so that people can choose between 12 or 18 months.
Is there any discussion on this amendment or any questions to the witnesses? Hearing none, all those in favor of NDP 17? Opposed? Lost. Shall clause Shall clause 245 carry? On division? On division. The next section's 245 to 269. Is there any there's no amendments in those areas. Is there any discussions? Are we okay to pass them as a block? On division from 246 to 269, carried on division. Thank you, folks. We're waiting to connect up with the witnesses from the Veterans Affairs Canada, which would deal with the clauses 270 through to 299. We're going to teleconference, right, or telephone?
So you can see with unanimous consent if the committee wants to stand all of those divisions inclusive.
stand all of those divisions 270 to 299 inclusively until we connect up with the witnesses from Veterans Affairs Canada? We get unanimous consent to do that, or we'll deal with them now. Agreed? Okay. Then starting and when they connect, we'll go back to, when we connect with Veterans Affairs Canada, we'll go back to them. Then starting on Division 13, there's no amendments from Clause 300 to 303. Can we see those as a block? Carry them on division? Agreed? Carried on division. Clause 304, NDP 18.
Merci, Monsieur le Président. Et ici,
Thank you, Chair. If you examine page 178, we're talking about the Service Fees Act, especially with regards to the Immigration and Refugee Protection Act. We're trying to make a list of that which would apply to the Service Fees Act with regards to immigration, temporary resident visas or permanent resident. There's also work permits, study permits, and extension of an authorization to remain in Canada as a temporary resident. Family group sections also. And also for a travel document issued under subsection 31(3) and for a permanent resident card. That is all subject to the Service Fees Act, if my colleagues remember. The Service Fees Act was debated for a very long time, much to my surprise, and included an adjustment to inflation. And so everything I just quoted in 304 will be subject to the Service Fee Act. To me, this is a bad proposal because we said it earlier. I believe that people from IRCC said that this was a vulnerable group of people, a very precise group of people that may be more sensitive to price changes for this kind of request. That is why my amendment simply seeks to state that temporary resident visas or work permits or study permits be subject to the Service Fees Act. It's to limit the kind of requests that would be valid under the Service Fees Act for temporary resident visas, work permits or study permits. And all the other categories would therefore be struck. I hope that my colleagues will approve of this so that we can ensure that there are more reassurances pursuant to Clause 304, so that they will be checked more diligently by parliamentarians. If these fees were to increase, the responsible minister will have to be accountable for this increase, which, in my opinion, should be the case. I hope that I will have my colleagues' support for this amendment.
Okay, it's on the floor. Mr. Alves and then Mr. Fergus.
Just confirming, Mr. Chair, this is NDP 18, is that correct?
Yes.
Okay, thank you. So I'd just like to ask the officials. Currently, it's my understanding that when someone applies for a, let's say they've gone from one particular status, let's say on a study permit, and have put in an application for something else or for another study permit, there's something called implied status. And they basically, until they've been turned down, can assume that they have some standing until that time. Is that correct?
So is your question referring to Clause 304?
I'm actually just in relation to Mr. Dussault, because to me, it sounds like he's trying to establish that in law of something which is already done in practice. So I'm just trying to elaborate whether or not this motion is actually necessary.
Yeah, I understand. I'm very sorry. Madame Carré just had she's late, and I know that she's running here, so I'm really sorry about that. I'm the expert for clause 300 to 303, so I can't answer on for the 304. I'm really sorry about that, but we'll certainly, well, we're hoping that she's going to
That's
show
okay.
up.
I would much rather have someone who can speak authoritatively to it, so I appreciate you
Yes,
saying that.
I'm really sorry.
Perhaps maybe we can just wait, Mr. Chair.
Are we agreeing in standing that clause down? Is there any other questions to Ms. Cote on any of the other sections prior to 304? You are with IRCC. Okay. Can we have unanimous consent to stand that down until the other witness from IRCC gets here? Okay. Thank you. That's not a problem. Thank you for coming. So we'll stand that down and come back to that. We still haven't heard from Veterans Affairs. Okay. On the next section, 305 to 402, there's no amendments. That's quite a few. Does anybody have anything in 305 to 402, or can we get unanimous consent to carry them on division? Agreed? All agreed. Clauses 305 to 402 carried on division. So we're starting then on, this will likely take a little time, on Division 18, Canada Infrastructure Bank, and we'll start with an amendment by BQ. BQ 8, Mr. St. Marie. Floor is yours.
Oui, merci, Monsieur le Président.
Thank you, Chair. The amendment BQ8 seems technical, but it's a fundamental one in my opinion. In creating the infrastructure bank, C44 brings significant changes, which is a complete aberration in my opinion. That hitherto has not been mentioned, and BQ8 seeks to remedy this problem. Infrastructure Bank will be mandated by the Crown for all government-decreed projects. If we take 4D, we'll see that the bank will be mandated by the Crown whenever the Crown seeks to use it, and so it has all the privileges and immunities. And now, on 18C, we see that these privileges extend to private projects that will go through the infrastructure bank. They can consider as its own investments made by others, and so it gives an unlimited loan guarantee to private investments. It goes beyond the 20 billion. It's an unlimited guarantee, which is an aberration. Second of all, and just as bad, Quebec and municipalities will no longer be able to work with these investments because it federalizes them. It protects them. So contrary to the Champlain Bridge, no longer will they have to make statements to turn the project into a federal jurisdiction one. This is an injustice, a very significant injustice. It removes this from municipal regulations and Quebec regulations. Energy East would have been adopted without an environmental evaluation by the BAPE. With regards to the Quebec Agricultural Protection Act, all infrastructures will be able to build, roads will be able to build on greenlands, ignoring Quebec laws. All of these different factors are no doubt unconstitutional. I cannot believe that this is in C44. If the government does not renounce its creation of this bank, at the very least, it should remove this abusive power, these abusive powers, by removing 4 from here. I hope that you have heard me. Thank you, Chair.
Thank you, Mr. St. Marie. Is there any discussion on the BQ8? Mr. Deltel.
Merci, Monsieur le Président. Alors,
Thank you, Chair. Good morning, one and all. Thank you to my colleague from Joliette for his very well said presentation. Perhaps we do not agree, but his MO is a model to follow. Now we're in one of the most important parts of this omnibus bill. Our party is against the creation of an infrastructure bank. We believe that the fact that this is surreptitiously included in C44 is unacceptable for such a significant thing. We want it to be split from the bill, and we are against, at the end of the day, the creation of this bank. Our votes will reflect our position. We will vote against.
Thank you, Mr. Deltel, and I remind committee members that witnesses are here today. I believe you were here yesterday as well. Is there any other discussion on Mr. Ferguson, then Mr. Ouellette?
C'est certain, Monsieur le Président, je suis en désaccord avec.
Of course, I do not agree with my colleague from the Bloc Québécois. We work together on other files, and I trust in his capacity to raise very important points. In this case, however, I completely disagree with his conclusions. This brings me to ask a question to our witnesses that are before us today. Mr. Campbell or Mr. Fleming, do you expect any problems with regards to the infrastructure bank's mandate with regards to Quebec jurisdiction?
No, we do not. If I may, this provision that was referred to, Mr. Chair, does not bestow additional powers on the institution. It merely clarifies the relationship between that entity and the Government of Canada for the purposes of managing its liabilities. The Crown Corporation needs to be, is required to be subject to any provincial law that applies. There is no additional power. And if I understood correctly the various commentary, none of that issue about agent, not agent status pertains to the project. This only pertains to the corporate entity under the Government of Canada, and therefore the project will continue to be the responsibility of the public sponsor, and that means if it was a municipality or province, then really they remain in control of whatever provisions apply to them in their home jurisdiction apply. And the infrastructure bank does not interfere in that process or relationship.
Thank you. Perhaps just a subsequent question then, Mr. Campbell. Just might as well, knock down this straw man while we can. The example that my honourable colleague had used in terms of the Canada East pipeline project, would that be a project that you would envision would qualify for funding from the Infrastructure Bank of Canada?
Any major infrastructure project that has the capacity to combine public and private interests would in and of itself be in scope. Of course, all the determinations of a particular government, nationally or federally, or review, all still applies as usual.
Thank you.
Mr. Ouellette.
Est-ce que
when the bank makes a decision, is the bank accountable for anything that is done by the bank, or is it not accountable? Or is it just liable in certain cases?
The bank, through the board, is accountable to the minister and to Parliament for the purposes of executing its mandate in terms of its functions bestowed on the corporation. So to the extent to which it is accountable for how it structures projects, its fiduciary responsibility pertaining specifically to the federal investment. However, the other parties to a particular project, for example, if it was a municipality or a province, they in turn have their, because it's a shared partnership model, would also be accountable to their constituents for that particular project.
So the bank would always be have a liability to environmental laws in Canada?
all of those existing statutes that pertain to anything in the infrastructure space or that continue to apply. The bank is not envisioning at all any interference. All existing rules, regulations, policies, procedures, reviews, all still apply as normal in that regard.
Clarified. Mr. St. Marie.
Merci, Monsieur le Président.
Thank you, Chair. I have to make a number of specific points. The Act says that when an infrastructure falls under federal jurisdiction, provincial regulations and municipal regulations are applicable as long as they do not go against the federal Act. With regards to our airports and agricultural zoning, is no longer applicable in Quebec. This was the case for post boxes when Canada Post installs those post boxes. They do not consult. Some people even went so far as to destroy their post box they were so against. If Energy East were to be funded by the Infrastructure Bank, the Quebec Environmental Protection Act may be able to repaint it, but they will not be able to say where it would go. Patrick Taillon, a constitutional expert, confirmed our fears. The bank would be mandated by the government, and fully private projects that go through the bank would also have this status. And so I would like to rise against what Mr. Campbell said. It goes against what this constitutional expert said, Mr. Taillon from the University of Laval. It also indirectly contradicts what a public servant said yesterday on the radio, when he said that all investment that goes through the bank would be fully covered by the Infrastructure Bank. I understand that Mr. Campbell needs to answer or meet the government's requests. It was the case for C29 when we talked about the financial sector that wanted to no longer follow the Consumer Protection Act in Quebec. At the end of the day, I believe that we were right. With all due respect, thank you.
Is there any further discussion on this point? All those in favor of BQ8? Opposed? Lost. Still on clause 403, amendment NDP 19. Floor is yours, Mr. Dussault.
Merci, Monsieur le Président. Et,
Thank you, Chair. Welcome to our friends who are back before us today. I'd like to thank them for all the time they spent here. My first amendment, because it is not the last one, as you can no longer see, Chair, it would seem that the 10 next amendments are all mine. I hope that my colleagues will be indulgent. Especially this one is important. We must mention that the text you have in NDP 19 is not my creation. Chair, it comes from the Liberal electoral platform for the 2015 election. For the words you see in my amendment. When they campaigned, they talked about the Infrastructure Bank, but when they talked about it, it was very different than that which we see today. The words used during the election campaign is very different to the one that we see in the Act, in the bill before us, which will create this Infrastructure Act. In the current bill, at section 6, clause 6, it is said that the purpose of the bank is to invest and seek to attract investment from the private sector investors and institutional investors in infrastructure projects in Canada or partly in Canada that will generate revenue and that will generate revenue. That's already something new. That was not said during the election campaign. And I've been confirmed that to generate revenue is user fees, tolls, etc. That will be in the public interest. Interest by, for example, supporting conditions that foster economic growth or by contributing to the sustainability of infrastructure in Canada. My amendment seeks to change this paragraph to go back to what the Liberal Party once said. I'll read what the Liberal Party once said. In their platform, they said, "We will implement the Infrastructure Bank that will provide low-cost financing that is low-cost financing for the construction of new infrastructures. The federal government can use its excellent will use its solid credit ratings and lending power to allow municipalities to easily and affordably subsidize the infrastructure projects that they need. The projects that they need, we're meeting needs here. When there's a lack of capital, provinces and municipalities get loan guarantees and small capital contributions. That was what the Liberal Party's platform said. To propose to Canadians an infrastructure bank. And now to my amendment. 6. The purpose of the bank is to provide low-cost financing, including by means of loan guarantees and small capital contributions. These are very familiar words, no doubt to you, to municipal governments for the construction of new infrastructures. It makes use of the Government of Canada's solid credit rating and lending power to allow municipalities to easily and affordably subsidize the infrastructure projects that they need. It's also important to notice this because it comes from the electoral platform. I would be very surprised if any of my colleagues across the way vote against this bill that is pretty much a paraphrase of their electoral platform that seeks to take this paragraph of their platform and put it in the bill. I'll be very surprised to see that their platform was not good enough for the infrastructure bank section of this bill, because that is what they had said to Canadians. That's what they said they were going to do. It's an ideal opportunity for our Liberal colleagues to take a paragraph from their platform and put it in their bill. I believe there would be very little opposition to this. I'll be very surprised if my Liberal colleagues were to say that they are against such an amendment. Chair, that is all I had to say for now to begin the debate on this amendment. And of course, I would like a registered vote.
Oh, you must have an interesting bookshelf. Some good documents on it. Any debate on this motion? Do I hear any? Go ahead, Mr. Albas.
Thank you, and committee members might remember an intervention I had with the finance minister. There are ways that the federal government can help municipalities. However, I don't think having the current mandate of the infrastructure bank combined with the NDP's amendment here will do it any good. In fact, it will actually really create a lot of confusion. I'm against the concept that the government is going forward, but I do want to compliment the member that there is further things that the federal government could do. Some provinces have their own municipal finance authorities. Those authorities could be working with the federal government instead of going to Wall Street for funding. They could be going to the government of Canada. But I don't think at this late stage that for the NDP to be trying to complete the Liberal platform in a backward way. Although someone told me one time, 3 lefts do make a right. But I appreciate the ability just to voice that. Thank you.
We always learn things here. Any further discussion on NDP 19? Okay, it's up for a vote. All those in favor, NDP 19?
Recorded vote, please.
Recorded vote. Madam Clerk.
Mr. Fergus. Mr. Grewal.
No.
Ms. O'Connell. No. Mr. Ouellet. Mr. McDonald. Mr. Deltel. Mr. Albas.
Sympathetic, but no.
Mr. Leiper.
No.
Mr. Dussault.
Bien sûr, c'est la plateforme.
The NDP is 19 is lost. NDP 20 on clause 403. Mr. Dussault.
Withdraw this one is pretty similar to the previous one.
Withdrawn.
It was more. The 19 was more precisely the words of the Liberal Party of Canada. So 20 is withdrawn.
Okay. NDP 21.
Donc, mon amendement ici 21.
NDP 21 seeks to delete lines 31 to 33 on page 238. This is under purpose and functions. It's to avoid that the bank receive unsolicited infrastructure requests from the private sector. We don't want there to be unsolicited proposals to be funded by the infrastructure bank. For example, if a province or a municipality has not made a project a priority, even if sometimes public sponsored is required, even if this request has to be made, a private investor can still turn up with a project and tell the municipality, here's my project, do you support it? What municipality would be crazy enough to say, well, no, we don't want infrastructure projects in our land? And that is why we're talking about unsolicited proposals that may receive the eventual support of a municipality, but that is not in their sights at the moment as a priority. But that would become so because the private investors want to make money. We're not talking about an infrastructure bank, we're talking about a privatization bank and a profitable bank for private investors. It's very different. For unsolicited projects, this is an even greater issue because investors say, we have an excellent project that will garner revenues of millions of dollars. Prime Minister, Premier, Mayor, would you like to go forth with this? It would be crazy for them to refuse such a request. But at the end of the day, it's an unsolicited proposal. My amendment seeks to avoid these unsolicited proposals from ever seeing the light of day. The project has to be already determined as a priority before it can be sent to the infrastructure bank.
Okay, thank you. Any discussion on NDP 21? Any questions to witnesses? All those in favour of NDP 21, do you want a recorded vote? A recorded vote, Madam Clerk.
Mr. Fergus?
Called?
Mr. Grewal?
No.
Ms. O'Connell? No. Mr. Ouellet?
Nay.
Mr. McDonald?
Nay.
Mr. Deltel?
No.
Mr. Albus?
No.
Mr. Leipert?
No.
Mr. Dussault?
Oui. The NDP 21 is lost. NDP 22. Mr. Dussault.
Oui, merci, Monsieur le Président.
Thank you, Chair. As you will see, we're now, again, with clause 403, page 239. We've gone forward to page 239. Especially with regards to lines 1 to 5 on page 239. Here we're talking about collecting and disseminating data that Statistics Canada has to carry out to make sure that we have credible and precise data on the infrastructure bank. It also seeks to amend the mandate of the infrastructure bank, so I would like to delete lines 1 to 5 on page 239. That speaks about generating revenue. I would like to speak against this proposal with regards to revenue, which was not mentioned in the electoral campaign, but that suddenly became acceptable for Liberals. Revenue infrastructure is suddenly a good thing, such as tolls. This is unacceptable to me. So we're trying to eliminate that line that talks about generating revenue.
All right, the motion is on the floor. Any further discussion from any side? All those in favour of NDP 22? Recorded vote. Madam Clerk.
Mr. Fergus? Mr. Grewal?
No.
Ms. O'Connell? No. Mr. Ouellet?
Nay.
Mr. McDonald?
Nay.
Mr. Deltel?
Nay.
Mr. Albus?
Nay.
Mr. Leipert?
No.
Mr. Dussault?
Oui. Lost. NDP 22 lost. NDP 23.
C'est en ligne un peu avec ce que je viens de mentionner, Monsieur.
This is in line with that which I've just mentioned. Same page. In section 7, we're talking about the functions of the bank. There's a list from A to H with regards to the bank's various functions and that in which the bank can actually invest. After line 11, we want to add a paragraph stating that the bank may invest in an infrastructure project respecting new or existing infrastructures only if no new fee, charge, levy, or other amount will be charged for the use of the infrastructure. Once again, it seeks to avoid the proliferation that is wished by the Liberals, the proliferation of tolls in Canada. The Liberals keep saying that more tolls and more paying is good, but we want to avoid this. Tolls and such are a bad thing. It especially harms the middle class that goes to work every day and that has to drive the same path every day and that has to pay for their drive at the toll on the same road. To me, this is unacceptable. This amendment means that the bank would not be able to invest in projects where there would be new fees, charges, or levies. I would like a recorded vote.
Is there any discussion from any corner? All those in favor of NDP 23, recorded vote. Madam Clerk.
Mr. Fergus.
Avec plaisir, je vote contre.
Mr.
With pleasure, I vote against.
No.
Ms. O'Connell. No. Mr. Ouellet.
Nay.
Mr. McDonald.
Nay.
Mr. Delta.
Contre.
Mr. Alves.
Contre.
Mr. Leipert.
No.
Mr. Dussault.
Oui.
Amendment is lost. Still on clause 403, NDP 24.
Merci, Monsieur le Président. Bien sûr.
Thank you, Chair. Once again, clause 403 on the infrastructure bank, but now we're on to page 241. For my colleagues, we're talking about the infrastructure bank's board. We know that the bank was created with a close collaboration with private investors such as BlackRock and McKinsey & Company. They more or less drafted this bill themselves. Well, not to deny the potential work and drafting of our colleagues here at the table. These companies closely worked with the drafting of this bill because we know that the Prime Minister met BlackRock many times. BlackRock has a lot of influence with the Minister of Infrastructure, with the drafting of infrastructure documents. For example, my amendment, as you will see, Chair, seeks to avoid having an administrator from those companies on the board. The same is true for any wholly owned subsidiary of those firms. This seems to rectify a clear risk of conflict of interest. Those people that drafted the creation of the infrastructure bank for their benefit, then what other company would take part in such consultations for an infrastructure project if they had nothing to gain from it? They're not just doing that for just to have fun or for the well-being of Canadians. They're doing that for their own shareholders and their own wallets and investors. It is for that reason that I seek to forbid any of these two companies to have a place on the board of directors, so they can also avoid being the chief executive officer of the bank. At least in this respect, it would allow us to avoid the undue influence of those who would benefit from this.
Mr. Dussault, and to remind people there are witnesses here if you have any questions to them. Mr. Ouellet.
Thank you very much, Mr. Chair. Just a couple of quick questions for Mr. Fleming, Campbell, and Mr. Grover. Is it normal in a law to name specific firms?
I would generally say, as an official, I think it'd be inappropriate to discuss specific names and individuals in this context without justification in that regard.
So it's not normal to name in Canadian law a specific firm?
I do not believe so.
Okay. Does the Conflict of Interest Act apply to the people who are appointed to the board of directors or who are running the infrastructure bank?
The Conflict of Interest Act applies to the board and any appointee by the Government Council, and then the Crown Corporation has to follow best practices in terms of conflict of interest and all provisions as any other corporation would.
And just one final question. Could you give a bit of an indication about the process that led to the actual development of the law, in the sense, who actually wrote this law? Did BlackRock write the law?
I've been in charge of this project for almost 6 months, and I've had no engagement with that firm, whatsoever. Let me go back. The government had consulted with perhaps hundreds of stakeholders from the infrastructure community, the financial community, on the debt and investment side, municipalities, provinces, territories, consultancies of all variety prior to the announcement in the Fall Economic Update. Between the Fall Economic Update and the budget, there was even deeper consultations with strata of various parts of the infrastructure ecosystem, including those in the federal, provincial, municipal system. And following the budget, as an official, I led the coordination of the drafting of the legislation in concert with the government. We used all available resources inside the Government of Canada, and we drew on hundreds of input from various stakeholders in shaping this legislation that led to the government's decision.
And just one final question: Are you a politician? Or can you just give me a bit of you're not a politician, I suppose.
I am a senior official, a technocrat, if you will, with extensive background in government and in financial services, banking, and investment.
You're a Weberian bureaucrat.
I am, indeed, and proud of it.
And just a very quick question. So how many years experience do you have in the bureaucracy?
25 years.
25. Thank you very much.
And just for the record, Mr. Campbell is Assistant Deputy Minister, Canada Infrastructure Bank Transition Office. Thank you both. Is there any further discussion on NDP 24? Recorded vote has been called for. Madam Clerk.
Mr. Fergus.
Contre.
Mr. Grewal.
No.
Ms. O'Connell. No. Mr. Ouellette.
No.
Mr. Bruson. No. Mr. Abbas.
No.
Monsieur Dussault.
Motion is lost. Still in clause 403, NDP 25. Mr. Dussault.
Merci, Monsieur le Président. Ici, je vise à...
Thank you, Chair. I seek to delete lines 9 to 12 on page 241, which seeks to eliminate the ineligibility for appointment. It would make the bank more accountable to Canadians. I think that it's a good idea for the general public to have a seat on this board, and that is what I seek to do. The greater public needs to have at least one representative around the table, be it a representative from civil society, a representative from a various department that seeks to ensure that the $35 billion of public money that will be placed into this bank be spent in an appropriate way, respecting taxpayers, so that it does not promote the pockets of private companies. Canadians are used to paying their taxes every year. Some people, well, everyone works very hard to make ends meet and gives a large portion of their money to government, and so this money has to be managed responsibly. That is why I believe that when we're talking about $35 billion, we're talking about a very significant sum that needs a particular level of oversight from someone who represents the public interest. Otherwise, this board of directors and all the directors therein may all be of the same camp, and they all want their own interest. Their own interest is their own pocket, and not the interest of the public. That is what my amendment seeks to remediate.
Thank you, Mr. Dussault. Any discussion on NDP 25? All those in favour?
Recorded vote, please.
Prisoner missed it.
Was quick.
Recorded vote, Madam Clerk.
Mr. Fergus.
Called.
Mr. Grewal.
No.
Ms. O'Connell. No. Mr. Ouellet.
No.
Mr. Bruson. No. Mr. Alves.
No.
Mr. Dussault.
Oui.
Recorded and lost. NDP 26, I believe.
Ouais. Ici, Monsieur.
In the same vein, Chair, I'm talking here about how important it is to have public oversight in this case. It would be by amending a sentence of the bill that seeks to state that we need the concurrence of the designated minister. We want the concurrence of this person. And so the amendment wants the minister to be more accountable. It will no doubt be the infrastructure minister, but this minister, regardless, has to be accountable for all of the infrastructure bank's actions and its potential failures, to make sure that parliamentarians can guarantee that the minister is accountable to the government or to the people, and to make sure that the infrastructure bank is very clearly laid out as being under his or her jurisdiction. And so if there is any failure, if money is incorrectly spent, or if the money ends up in the pockets of influential liberals, to not throw back to the past of the Liberal Party. We want to make sure that the relevant minister be accountable to Canadians. We do not want the minister to say, well, the bank is independent, it has nothing to do with me, they can do what they want, and that's it. That is the risk that may arise. The minister could completely withdraw himself from any responsibility. My amendment seeks to increase the accountability for what is going to happen. Increased accountability for the bank. I'd like a recorded vote.
Any discussion on this point? Okay, NDP 26, recorded vote.
Mr. Fergus.
Called.
Mr. Grewal.
No.
Ms. O'Connell. No. Mr. Ouellet.
No.
Mr. Bruson. No. Mr. Alves.
No.
Mr. Dussault.
Oui.
Lost. Still on clause 403, NDP 27.
Merci, Monsieur le Président.
Thank you, Chair. In the same vein, once again, and so I won't talk too long about it, once again, so the bank has to submit infrastructure projects to the designated minister, who may, with the concurrence of the Minister of Finance, recommend it for the approval of the Governor and Council. It's just, once again, to increase the accountability of government with regards to this bank. If there are any ill-advised investments and ill-advised projects that are complete failures, white elephants, it has already been the case in Canada, that the ministers be accountable for these expenditures, and so they cannot simply step away from it, and rather than saying, as usual, we have ministers that often say, well, it's a Crown corporation, it can do whatever it wants, so we're not responsible for its actions. They make their own decisions, and we, the government, has nothing to say. It would allow Canadians to make sure that the government is accountable for the Infrastructure Bank's actions because it would need the concurrence and the approval of the Governor and Council for Infrastructure Projects.
Mr. Albus.
Question to officials, Mr. Chair. Appreciate your expertise on this. When the bank is created and becomes a Crown Corporation, it will probably operate, I assume, like other Crown corporations where the debt is reported on their books and not the public accounts specifically. Is that correct?
No, it's not correct. It will be a consolidated Crown. Therefore, its net liabilities will be reflected in the financial statements of the Government of Canada. More specifically, any project to which it's deemed to have federal support or under market support, it would be counted against that $15 billion profile that's transparently set out in Budget 2017.
So every year parliamentarians will be able to scrutinize that as part of the overall picture. Is that correct?
That's correct. It will be reflected in the government's financial statements, and it will also be identified in the annual plan that will be tabled before Parliament by the corporation.
Thank you.
Thank you. Mr. Ouellette.
So I just wanted to, so we have the amendment here from Mr. Dussault, but I also just wanted to point out, on page 243, financial management and control, corporate plans, the bank must annually submit a corporate plan to the designated minister who may, in concurrence with the Minister of Finance, recommend it for approval of the Governor and Council. Operating budgets, the bank must annually submit an operating budgets for its next financial year to the designated minister who may, with the concurrence of the Minister of Finance, early in the morning, recommend it for the approval of the Treasury Board. And the bank must annually submit a capital budget for the next financial year to the designated minister who may, with the concurrence of the Minister of Finance, recommend it for the approval of the Treasury Board. So there is a lot of oversight from parliamentarians.
Yes, there is a well-established Crown Corporation operating framework that largely is set out in the Financial Administration Act, which applies to this new corporation, except for a couple of very specific areas. And then in the corporate plan, it's very specific that the corporation needs to come forward to the responsible minister, that in turn needs to be approved before it can carry out any of its activities on an annual basis.
Mr. Albus.
Not to leave any stone unturned, can you please give us a couple of you said there was a couple things that were not subject to, that are specific to the bank. Can you, or to this infrastructure Crown Corporation? I don't like calling it a bank.
So, for example, there's a higher standard for auditors. So in the FAA, it could be the Auditor General or a private sector auditor. Here in the Infrastructure Bank Act, it's saying joint auditors. There's an additional provision in the FAA for acquiring subsidiaries. Typically, that requires the Governor of Council's approval. But here, given the nature of the bank's activities, it would just require the designated minister's approval. So those are some examples.
Okay. Thank you.
Any further discussion? Okay, on recorded vote, NDP 27.
Mr. Fergus.
Contre.
Mr. Grewal.
No.
Ms. O'Connell.
No.
Mr. Ouellette.
No.
Mr. Bruson.
No.
Mr. Deltel.
No.
Mr. Alves.
No.
Mr. Leipert.
No.
Mr. Dussault.
Oui. Okay, NDP 27 is lost. Okay. Thought we could move ahead to PV 19, but NDP 29 will create a conflict, so we can't do that. Elizabeth, sorry about that. I know you have a conflict.
I appreciate you even considering it.
Okay, NDP 28.
Merci, Monsieur le Président. Ici, c'est pour ce qui est.
Thank you, Chair. This is the 5-year review of this bill. It's not very perfect. It's not ideal because all of my amendments have been rejected. So the bill is as it is. But now we have a unique opportunity so that the Liberals can say in their speaking points that they accepted opposition amendments. Amendment 28 merely says that rather than having a 5-year review, we'll still have a 5-year review, but on top of that, on the first anniversary of the day on which this Act comes into force, there would also be another review of this new bill. And so about 1 year after today, after the implementation of C44, perhaps end of June, in June 2018, we would come back and study the effectiveness of this bill. Otherwise, if we merely have a 5-year review, we would only have a study in 2022, which is too far from now, in my opinion. I believe that parliamentarians deserve having this review in 1 year. And then 5-year reviews would happen every 5 years from there on in. We would simply want to add a 1-year review after the coming into force of the Act. This is a unique opportunity, unprecedented opportunity for the Liberals to accept an opposition amendment, and then they will be able to rise in the House and say we're such good people that we accepted an opposition amendment on the infrastructure bank. It would be a speaking point in and of itself.
Thank you, Mr. Dussault. Mr. Ouellette.
Merci beaucoup. Je suis...
Thank you. I'm just interested by the wording. Every 5 years, beginning on the day on which this Act comes into force. So the coming into force. But when will it come to force, really?
Subject to parliamentary approval, it would be when this Budget Implementation Act number 1 comes into has royal assent. Again, subject to Parliament's will.
So as soon as it goes to the Red Chamber and the Governor General gives his nod and receives royal assent, is that, or does that take a declaration or something from the Governor, the Cabinet again?
No, it's on royal assent of the legislation.
On royal assent.
The Canada Infrastructure Bank would be incorporated as per legislation, and then of course there's the corporate plan and other activities that follow. But once Parliament passes the legislation, it will be incorporated under the Act.
And so that would be 5 years from that date, sometime,
That would be correct.
maybe at the end of June, early July.
So you'd have the similar, this is a provision that exists in other legislation, including the EDC and BDC Act, where initially they had a 5-year review and then it went to 10-year review. Of course, we know this exists under the Bank Act and the Insurance Companies Act. When it's the next available time in Parliament to have that review, it becomes a procedural issue before they bring those reviews forward to Parliament.
Just in my mind, I'm just trying to establish when the next review will be. So it would be in 2022, probably. Most likely, not this Parliament, the 43rd Parliament, somewhere in the 3rd year almost.
Yeah. Generally speaking, it would be 5 years from the end of this June if this bill were to pass, and then to work out, the responsible minister would work out when to bring the review forward in advance of that time to ensure a review was undertaken prior to that date that is now established in legislation. So the government would have to bring forward a review prior to the expiry of that 5 years.
And we'd always have when the plans are tabled, we'd always have the right, I guess, to question them here at the Finance Committee if we desired, or to question the Finance Minister. We would always have that level of accountability as we desired.
And you would, and let me remind, if I may, 2 points during the year. The corporate plan and the annual report are documents tabled in Parliament on a rolling basis that provides opportunity to potentially discuss the operations of the Canada Infrastructure Bank.
Thank you both. That the end discussion on NTP 28.
Recorded vote.
Madam Clerk.
Mr. Fergus.
Contre.
Mr. Grewal.
No.
Ms. O'Connell.
No.
Mr. Ouellette.
Nay.
Mr. Bruson.
No.
Mr. Deltel.
Contre.
Mr. Alves.
Contre.
Mr. Leipert.
No.
Monsieur Dussault.
Oui. NDP 28 is lost. Turning to NDP 29, and this is a motion that was it's considered moved by Mr. Aubin, who's with the NDP Transport Committee, I believe. And a technical point here: if NDP 29 is adopted, question cannot be put due to line conflicts with NDP 30 and PV 19. So, Mr. Dussault, the floor is yours. If you want to.
Oui, merci.
Say anything on it?
Ici, on est.
Thank you. We've now gone a bit further in the bill, we're now talking about privileged information. The bill is very strict with regards to information. It does not have to be so stringent because exemptions already exist pursuant to the Access to Information Act. My amendment therefore seeks to completely remove 28.1 to simply keep 28, where we would talk about situations where privilege of information may be possible, listed A to D under 28.2. It also seeks to change certain technical aspects under 31 about offences. Some offences can lead to a fine of not more than $10,000 or imprisonment for a term of not more than 6 months with regards to information confidentiality. In our opinion, we are trying to say that yes, there can be protected or privileged information, but the Access to Information Act already provides for the protection of commercial information, economic or strategic, or national security information. All those issues are already subject to the Access to Information Act. Such information can already be protected by getting an exemption under the Access to Information Act. We do not need, therefore, 28, which is even more strict than the Access to Information Act. Once again, to protect the public interest, to have access to data and documentation and information that comes from this bank. And perhaps the reasoning why one project has been chosen rather than another, which is often the MO of public procurement. Decisions are made, but they need to justify their decision. In this case, I do not believe that the public that Canadians would be able to understand why a project was chosen rather than another. I think that the restrictions under the Access to Information Act would be appropriate with regards to information that can be provided to Canadians with regards to access to information. The issue of offences seeks to bring technical changes because I'm changing Section 28. I hope that I have my colleagues' support because we want this Crown Corporation to be similar to other Crown corporations. CBC, for example, is perhaps not the best of examples of a Crown corporation that is protected with regards to confidential information, economic and commercial information also, because they are competitors to other private broadcasters, and so it's logical to have an exemption for that corporation, as is the case for Via Rail and Canada Post. I think that the Infrastructure Bank could be subject to the same rules. We do not need such stringent and strict rules that hinder the public's capacity to get information from this bank, which will be a purely opaque organization. This is inappropriate when we're talking about 35 million taxpayer dollars.
Thank you. Mr. Ouellette, NDP 29.
NDP 29, yes. So I'd like to ask Mr. Campbell, I was just wondering if there's other examples for similar Crown corporations that have similar legislation like this in 28.1 to 2, A, B, C, and D. Just wondering if you could inform us about that.
Yes, and Mr. Chair, this narrow exemption that's included in this legislation parallels the similar exemption that exists under Export Development Canada as well as the Business Development Canada, so 2 other crowns. It is specifically targeted to protect the counterparty or client information of either a financial participant or even another order of government. It's their information that is being protected, not the project and not the activity of the bank. It's precisely to give assurance to those counterparties that their information they may voluntarily put forward to the government is not released. And the latter point, the Information Commissioner would still have jurisdiction to oversee how access to information and related provisions are applied in the corporation.
I was also wondering if you could just give a bit more information. So Mr. Dussault had mentioned that there was another section that also deals with, I guess, confidential or privileged information. And how would this section, well, this section also, I guess, lays out that that privileged information may be communicated, disclosed, or made available in the following circumstances. But how do these two sections then work together?
Yeah, so the section 28.1 discusses what information is privileged, and then the section 28.2 provides certain exemptions from that. So for example, if there's consent of the other party, then that information can be disclosed. That's how those two sections work together.
And then Mr. Dussault, you had mentioned, what was the other section, Mr. Dussault, you had mentioned?
Je parlais aussi de la section sur les infractions.
So with regard to offences 31.
Section 31?
31.
28, 29, commettre une infraction encore sur déclaration.
Est-ce que, moi, ma question, ce serait, est-ce qu'il y a des...
My question would be, are there any similar provisions with regards to offences in other bills for other Crown corporations?
Provisions in the EDC Act and the BDC Act for violation of the privileged information provision. They are also an offence under those acts.
Okay.
Mr. Dussault asked your question for you. You two work well together.
Yeah, that's good. Yeah, okay. Thank you very much. Merci beaucoup, Monsieur Dussault.
Thank you, Mr. Dussault.
That it on NDP 29.
Juste peut-être une question aussi.
Perhaps just a question. If my amendment is adopted, correct me if I'm wrong, but the Infrastructure Bank would still be able to refuse access to information requests pursuant to the exemptions that already exist for economic and commercial and strategic information.
The Access to Information Act applies, therefore the various exemptions under the existing Act will apply depending on the circumstance, and the bank will be in charge with fulfilling the obligations under that Act, whether it's whatever applies or exemptions. This is one additional very narrow exemption that just provides additional to the counterparties who have to put forward information to the bank in a very narrow way, but the bank, the management and the board will be responsible for adhering to the legislation.
On peut traduire ça par c'est pour ça.
So it's simply to satisfy BlackRock and private investors, one could surmise. That is why we have 28.1.
Are we ready for the question?
A recorded vote.
Madam Clerk.
Monsieur Fergus.
Contre.
Mr. Grewal.
No.
Mr. Dhaliwal.
No.
Monsieur Ouellet.
Nay.
Mr. Bruson.
No.
Mr. Delta.
No.
Mr. Albus.
No.
Mr. Leipert.
No.
Monsieur Dussault.
Bien sûr.
NDP 29 is lost. Still in clause 403, NDP 30.
Ici, c'est pour...
I'm not going to spend too much time on this. Once again, it's for the offence, section 31, to impose consequences to those who contravene section 29, those who use, without written consent, the acronyms, for example. My amendment was not adopted, and so I would like to delete line 28, which for these offences that can lead to $10,000 fines or 6 months incarceration. If investors make an official request to be better protected with regards to information, well, we saw that BlackRock got its way, and so those who will flout 28.1 will be subject to severe consequences. And so I believe that we should remove the aspect of Section 28 completely from this bill with regards to offences.
On NDP 30. All those in favour, you want a recorded vote?
Yes, please.
Madam Clerk.
Mr. Fergus.
Contre.
Mr. Grewal.
No.
Mr. Dhaliwal.
No.
Mr. Ouellet.
No.
Mr. Bruson. No. Mr. Deltel.
No.
Mr. Albas.
No.
Mr. Leipert.
No.
Mr. Dussault.
Oui.
NDP 30 is lost. Turning to PV 19, it's deemed moved. Ms. May had to go back to the House. Is there any discussion on PV 19? All those in favour of PV 19? Opposed? Lost on division. Just I have one question, Mr. Campbell, coming back to Mr. Albas's question earlier on the debts and liabilities of the Canada Infrastructure Bank. How are they recorded? Are those liabilities recorded in the public accounts? Do they go against the long-term debt of the Canada? Can you explain that a little further on the liabilities of the corporation, which seem to be handled differently than other Crown corporations, if I understand correctly?
I'll let my colleague, Mr. Fleming, answer.
Okay.
Thank you. So the net liabilities of the infrastructure bank would be recorded in the public accounts on a consolidated basis. Therefore, it would be a part of the total assets, liabilities, and debts of the Government of Canada.
Okay. Yeah, Mr. Ellis?
Just on that point, I guess it would be just the nature of the activities of the Crown Corporation itself. It would look quite strange to have such a heavily leveraged, because again, the government is counting on you put in $1 and they're, at least it sounds like they're hoping that they'll get $2 to $4 from private sources. That's going to be highly leveraged. So I guess it would actually make the infrastructure bank look less over-leveraged, I guess, by having it in the government. Is that part of their policy rationale?
I would say, Mr. Chair, it's the opposite in the sense it's transparent that a project would not necessarily be leveraged in the sense that every participant will have a tranche or a share in that project, and the Government of Canada share through the bank would be transparent. And to the extent to which there's a value of that investment that goes below par, then it gets recorded against that profile of $15 billion. Then it'll be recorded as a net liability against the Government of Canada's books in a very transparent way.
Well, I think you and I can agree reasonably that transparency is a number as long as it's made public, and whether it's on the government's books or it's on an independent Crown corporation, that's still transparent because they're still reporting every year. The question is that the magnitude of the debt compared to it looks far less leveraged when you put it in the overall categories of liabilities of government. I'm just saying, to me, that's, if you were to have the other arrangement, it would just stick out like a sore thumb on a regular basis, while this way the government can achieve its policy goals while, to me, minimizing that perception of the corporation.
But it would be in both, would it not? It would be recorded in the Crown Corp, on the infrastructure bank, and on the public accounts.
The infrastructure bank itself would have its own financial statements that would be a listing of its assets and liabilities, and that would be for the corporation on a project-by-project basis. We've already testified before that there will be an accounting determination on an annual basis by the Comptroller General, and we have two auditors, the Auditor General as well as a private sector auditor, to determine what is the ongoing value of federal support in a particular project. The government has been transparent that this is a mechanism to deliver federal support, and it has set a limit over a period of time of a maximum of $15 billion against the fiscal framework set out over 11 years in Budget 2017. So that is going to be very transparent, Mr. Chair, as to how these projects will be reflected both at the bank as well as on a consolidated basis, as my colleague mentioned, on the Government of Canada's books, to be fully transparent, and that number may fluctuate over time.
But again, unlike a bank, there will not be a capital requirement for how much cash it has to have on hand. To me, my understanding is the government is intending to try and maximize as much infrastructure from private means, and so I can't see them, like a bank, having a capital reserve. This is ultimately going to be, at least, I think it will take a little while for all the $35 billion initial investment in money and guarantees. It'll take a while for that to be invested, but to me, that's the purpose. So this is going to be one heavily leveraged bank, if you want to call it that, because it won't have capital reserves on its own on a regular as part of its mandate, will it?
Thank you for your question, and Mr. Chair, this is not interpreted as a levered corporation in that respect. First off, to reduce cost and treasury function, unlike other Crown corporations, the government's not going to give it a lump sum amount of money to which it has to manage. Cash will be released to this corporation as projects come forward, such that it can make investments, i.e. purchases into a project, either through debt or equity means, and then other parties will do the same. The objective is to bring in not additional debt, but actually equity, so that it's not levered. The purpose is actually trying to attract more investment on a project-by-project basis. The bank need not have a capital reserve. It only needs to have the amount of liquidity it needs on a project-by-project basis. The Government of Canada will raise its debt. The Government of Canada will manage its funds prior to transferring it to the Crown Corporation. It need only manage on a project-by-project basis as one participant structuring that project.
Okay, Mr. Dussault and then Mr. Ouellette, questions to witnesses. We're still on clause 403, but we are in the infrastructure bank. Go ahead.
My question has to do with the title. Why did you call it a bank? Because you keep talking about a Crown Corporation again. You keep mentioning corporations. So why did you call it an infrastructure bank? When, in my opinion, for the average Canadian, it's not quite a bank by definition. A bank provides financial services. So we're talking about an investment bank. We're investing in societies here, in corporations, to make a profit. So why calling it a bank? Why did you call it a bank rather than describe it in a different way?
Thank you. And Mr. Chair, first let me say, in the previous 3 years prior to taking on this role, I was in charge of the Bank Act in Canada, and I understood bank and banking and name use and functions. It is quite clear that the entity as constructed, even though it's a Crown Corporation, is effectively a bank for the purposes of managing risk transfer between parties, facilitating an arrangement between borrowers and savers. It is not a Schedule I bank that takes deposits, much like other banks, but there are many other private market participants that do project finance, merchant banking, where they're involved in structuring a project, bringing folks together in a very bank-like way of transferring and managing that risk. So for those intents and purposes, this is a merchant-type investment bank, bringing parties together and structuring it. It just merely does not have the deposit function, and there's only one Schedule I type of banks that take deposits. There are many other types of banks that are involved in those type of wholesale or other forms of financial restructuring.
Last question.
Yeah.
We hope.
Mr. Campbell, je vous trouve absolument fabuleux.
I find you quite marvellous, Mr. Campbell. I think that once again, you should be head of the bank. I hope that you will continue to be involved in this because we need your expertise.
About liability. Can the bank, generally with all the whole articles, and we've already had this discussion before in OGO, but can the bank make profit on a project itself?
Indeed, yes, it can, in the sense that if the Government of Canada, through the bank, made an investment into a project that had risk at the outset, so it met the test of having to be in the short run to absorb some risk. If that project performs and it exceeds expectation, then the bank itself could get net proceeds like any other investor in that project. Its equity could be of a higher value over time, or it could get repaid a level of debt with interest that could be the equivalent of a profit in a project.
So the opposite side of that could, let's say, a project fails. Could the bank lose everything, or how would you divide up the assets? So, for instance, they build a greenfield project, a brand new project, and somehow it just doesn't work out how we kind of hoped, and there's the private investors decide to leave, they want to sell off. How would you see that or envision that working itself out?
The bank, Mr. Chair, the bank will follow modern and robust legal agreement and investment agreements that contemplate all these potential scenarios, both through the finance planning stage, the construction stage, and the operating stage, that will ensure everyone knows the rules of the game through agreement. If something were to happen, the project doesn't perform as intended, which that likely means the private investors who absorb risk would take a loss, or their returns would be reduced as intended. If one of the players were to go into some form of default, well, provisions exist to have someone else enter into their place, which usually happens during the construction phase, no different than any traditional procurement, and these are managed. And to the extent to which something happens to a particular investor, by the way, who has already put their money in, that's in the project, then they may, through a normal court process, have to transfer their liability or sell their position in the project to another investor. So this is largely normal routine in the world of infrastructure and big projects to ensure projects continue to get built and keep moving, and partnership agreements contemplate and manage all of these scenarios, and that system works very well in Canada.
So when you talked about, Mr. Campbell, about a merchant bank, you were not talking about a piggy bank in the sense that this is something that, $15 billion where we're just handing it over to private investors and saying, here's a gift, but really trying to use this to leverage to build infrastructure, but also we maintain an equity stake in a lot of these projects.
So the purpose is to use federal support strategically into a project to put as minimal amount of federal support needed to absorb a risk in a project that otherwise would not have been built, or has too much risk, particularly for another government and that private investor to come together. And the comparator would be a project where governments bear all the risk and pay all the funding. So even the federal government would have paid more. So the objective is to have the merchant bank or the Canada Infrastructure Bank work with other partners, including municipal, provincial, or other federal partners, to determine really what is the minimal amount of support needed to make a project viable.
Okay.
Just one final thing, my dear Chair.
Okay. You still got one more question?
Just one tiny thing. If you ever pick a name, I hope you pick the L'Oreal Canada Infrastructure Bank. I think that's a beautiful sounding thing, Mr. Chair.
Mr. Leipert.
I thought maybe I'd just briefly try to answer Mr. Ouellette's question that yes, if the federal government guarantees a project with a loan guarantee and it goes broke, the infrastructure and bank investment of the federal government is at risk.
Okay. Is that it on clause 403, or can I call a clause? Mr. Albus.
Yeah, just again to reiterate our position on the infrastructure bank, that we don't feel that it is a necessary piece of infrastructure here in Ottawa. Simply that there could have been allocations made to P3 Canada. Certainly understand the motive of the government, just do not agree that this is the correct mechanism. And I certainly hope that the other place does make serious consideration of whether this committee process, of 2 hours of testimony. I do also know that the infrastructure committee, so we'll give it 4 hours of testimony coupled with the clause by clause, I don't feel is adequate given the amount of investments that will be made. And certainly our votes are going to be against this, bearing in mind that when the previous government decided to invest heavily in infrastructure, when the time came, we did so quickly and efficiently without having to add new bureaucracies here in Ottawa. where the governance questions have been played out in the media multiple times, and with the government not being entirely clear which side it lands on. So we will be voting against the proposal, but I just want to thank the professionals that are here today for the work they do for Canadians. Thank you.
Mr. Ouellette.
Tiny question. Mr. Campbell, what's the difference between the infrastructure bank as it's conceived and PP3P Canada? Or Mr. Fleming. Mr. Fleming gets it.
Sure, thank you very much. In terms of the functions of the organizations, public-private partnerships are a very useful contracting tool when they're applied carefully and for the right kind of project. So they can use private sector incentives to get projects built on time and on budget, and that has obvious benefits. In terms of their capital structures, however, P3s in Canada primarily involve financing through loans for a portion of the project costs. And those loans still ultimately have to be repaid by the government, usually the municipality that owns the infrastructure. What the government heard in consultations is that there's a need to help build more infrastructure than can be just paid for using the public purse. And the infrastructure bank can bring an additional party to the table for funding projects, so it does not just rest on the three levels of government. And this would also free up public funding for other projects, including infrastructure that would not have the required revenue streams. So in order to attract that private sector investment and do it in a way that protects the taxpayers, a new institution was needed that would have the right kind of expertise and could be the counterparty for the negotiations with the sophisticated private sector equity investors. That's a different skill set than the functions of PPP Canada, which are focused on providing advice for structuring procurement contracts involving P3s.
Mr. Leipert.
Mr. Fleming, would you not agree that there are multiple P3 projects around the world that are operating and are operating in situations with tolls, with whatever, where the government investment is zero, and yet the infrastructure is being built?
Fleming or Mr. Campbell, whoever wants to answer.
Yeah, there can be projects.
No, I'm asking, are there, not can be, are there currently projects around the world that is happening?
I believe there are different types of projects.
I'm asking you a specific question. Are there projects around the world that are currently operating today that are P3 projects that have no government money and they are operating by way of tolls and other revenue returning projects?
Completely privatized.
Completely privatized with no government money.
Right. So there can be projects that operate.
No, I didn't ask whether there can be. I'm asking you, are there specific projects today that is the case?
I believe there are. I don't have specific examples.
The answer is yes.
Any further discussion? Mr. Albus.
Again, elaborate. And again, I'm not asking you to say whether the policy choice is correct, but whether because first of all, P3 Canada has a specific skill set. But if the government had chosen to say we would like to have an expanded focus to include elements that would encompass the desire to draw in more investment, to not just get all three levels of government more attuned to private sector investment with P3s, they too, P3 Canada, with the proper guidance, legislative changes, and support, could offer many of the same attributes that the infrastructure bank. It was a policy choice, I'm sure, that the government made to go ahead with a completely independent, or a completely, it's not independent, a completely different Crown Corporation. But theoretically, it would be possible if the government chose so. Is that correct?
I don't think we're going to comment on hypotheticals. We can explain what's before us in the legislation, and can reiterate the point that PPP Canada is a procurement about downstream how a project is constructed. The Canada Infrastructure Bank is designed and purposefully about arranging the project financing, which could include a P3 structure in procurement if that's the project wants, but we really see them as two separate distinct functions and skill sets.
Okay, well, just to me, for someone who sees the value of a dollar, who sees that, yes, there could be more private investment in Canada, and that if you were able to bundle those together, that there might be some further strides that could be made. However, I do not believe fundamentally that you need a new bureaucracy in Ottawa, particularly when it's going to take 5 years before this thing actually gets operating smoothly. So I see the hammer here. Appreciate the submission. I just want to have that on the record firmly, that I believe that there are innovations in infrastructure funding could be made, but not through this mechanism.
Okay. Any other comments? Is this going to take 5 years to be up and running?
The objective set out for the bank and the mandate subject to parliamentary approval, the bank can be operating this fall, and we have a planning date of November, and then really right out of the gate working on the advisory function and working with our municipal, territorial, provincial and other partners on structuring projects. And many of these projects do take time to develop, and as you may know, the government decided to locate the bank in Toronto, closer to the ecosystem in the infrastructure universe, so it will not be an Ottawa-based entity.
Okay, we're not exactly on any amendments, but the discussion is a valid one. Mr. Albas and Mr. Ouellette, and hopefully that'll end the discussion.
No, just on the point about 5 years. Any Crown corporation, it's going to take a while before all the policies, before the people begin to have a working structure, and that's before it starts to step in stride. So I appreciate that the mechanism will be there, but whether or not that all the safety protocol, safety I should say, the value for money protocols and internal processes can be set up, just having people in a leased location does not a institution make.
Mr. Ouellette.
I was interested in the comment that you made, Mr. Campbell, about information. So in November, setting up the advisory, I was just wondering how you're going to be sharing information with municipalities and provinces and the partners, the potential partners, and how you're going to be building the bank and informing, I guess, those partners about the possibilities using this new entity.
I'm already in continuous engagement with both sets of stakeholders involved in the bank, and I'm having a discussion with my ADM colleagues in the federal, provincial, territorial universe tomorrow, really to tee up that the moment the bank is operating, and quite frankly, the moment we have established people, they will be interfacing with many of our counterparts on envisioning projects, and we have a lot of demand now from our municipal, territorial, and provincial colleagues to, they want to interface with the experts at the bank so they can start thinking and doing their long-term planning as envisioned. We anticipate it being a center of expertise and advisory function to help other orders of government think through whether this is a viable option or not for them, and then over time we'll develop the data for all parties to help better inform long-term infrastructure decision making.
And how will you be ensuring that, or connecting, for instance, private investors and private funds with the partners, the municipalities and the provinces?
That is the precise value-added role of having an independent arm's-length entity, that a public sponsor brings forward a project, and then really it's the bank to determine with that sponsor whether or not there's an appropriate investor base for that particular project. So that really is that market determining function of whether or not a project is bankable, and that provides the feedback mechanism to the sponsor of that project, whether they want to continue under the infrastructure bank model.
Okay, thank you. That ends the discussion on point clause 403. Shall clause 403 carry? On division? Recorded vote? Recorded. Okay. Madam Clerk.
Mr. Fergus.
Cool.
Mr. Grewal.
Yes.
Ms. O'Connell. Yes. Mr. Ouellette.
Yes.
Mr. Bruson?
Yes.
Mr. Deltel?
Contre.
Mr. Albas?
No.
Mr. Liper?
No.
Mr. Dussault?
Contre.
403 is carried. We do have a person on the line from Veterans Affairs, but I'm wondering, there still is 3 sections related to infrastructure, so we could let 2 sections, 3. There's no amendments to 404, 405, and 406. Could we see this as a block and carry them on division? Agreed? Carried on the divisions, section clauses 403, 405, and 406. And I'd thank the witnesses, and you were released. Can we go back then to Division 12, which is the Canadian Forces members and veterans, clauses 270 to 299. And we do have on the line with veterans from Veterans Affairs Canada from Charlottetown, Sean McDougall, who's the Senior Director, Policy Director, Strategic Policy and Commemoration. So we have the witness on the line with Veterans Affairs Canada. If there's any questions on the clauses in the bill 270 to 299, there is no amendments. Does everybody okay to see them as a block and move them as a block? And before we do that, is there any questions to the to Mr. McDougall, who has been on the line about an hour waiting in case there's questions? Does anybody have questions for Mr. McDougall on Division 12? Okay, Mr. McDougall, thank you very much for waiting on the line. There is no questions. Shall clauses 270 to 299 carry on division? On division, carried. Okay, yeah, we'll go back to clause 304, but I'm wondering, seeing as we've been at it 2 hours, do people want to take a 10-minute suspension, stretch their legs a little, and then come back to clause 204? We agreed to do that? Okay, suspended for 10 minutes. reconvene, and we'll ask the representatives from IRB, IRCC, keep changing names around this place. So we want to come back to, we stood clause 304. There was a question by Mr. Albas, I believe, and we have with us now Victoria Henderson, Acting Director of Cost Management with IRCC. So clause 304 is on the floor, and Mr. Albas, you had a question.
Well, then that's the big question on my mind is, can I remember my question? So, no, actually, I do appreciate, so this is based on the NDP amendment specifically laying out the status. So right now, my understanding is there is a practice that if someone whose permit has come up, regardless of what the permit is, and they have applied for another, whether it be a work permit, a study permit, etc., they are given implied status until they are, if the application is turned out, then they have no status. But I think that's what the amendment he's trying to put in place into this bill is to say there is that. So my question is, if this is already happening in practice, can you say yes or no, and maybe we'll go from there.
So I'd like to apologize first for my delay in appearing.
Faster than you expected. That's not a problem. Go ahead.
I'm not the operational expert, but what I can say is that for temporary residents, if they did apply for an extension to their status, and if that application was received prior to it expiring, then yes, they do have an implied status until a decision is rendered.
Okay, so given that that is the current practice, and it was a practice under the previous government, it's a current practice, at least I've seen under this government, is there a need for further legislation on this topic?
I can't comment on any specific further legislation that would be required in that context. The context for our proposal is specifically related to an exemption for permanent residents and not temporary residents.
Okay. Well, maybe I'll let Mr. Dussault ask some of his questions, because I'm sympathetic, but from my experience as a member of Parliament, this practice happens every day, and it is, to me, I'm not entirely convinced it needs to be legislated further.
Mr. Dussault, and we are on amendment NDP 18, Pierre.
Merci, mais j'entends bien mon collègue, mais je suis pas sûr qu'on parle la même chose.
I heard what my colleague had to say, but I don't think we're talking about the same thing necessarily. C44 seeks to put exemptions for the Services Fee Act. My amendment sought to reduce this exemption only for temporary resident visas and study visas, and an authorization to remain in Canada as a temporary resident. Whereas the current bill, as you can see, goes from A to H regarding the requirements that are exempt from the Service Fees Act, and so I would not necessarily strike a link with the renewal of a request, or if we're on a study permit asking for a work permit while we're still under a valid study permit. I don't know if there's a link to make between the two, because in my opinion, fees are still applicable. Perhaps you could answer this question. If someone is here on a study permit and they ask for a work permit, do they have to pay the fees?
Again, temporary resident is not within the scope of what we're seeking. We are specifically seeking an exemption to the User Fees Act or the Service Fees Act for permanent residents. IRCC currently has an exemption for temporary residents to the Act. We also have an exemption for citizenship, so those have already been legislated. What we're seeking here specifically is for permanent residents, and the rationale for why we're seeking that is that due to the unique nature of our clientele, which is internationally located, they're across the world, we need flexibility when it comes to setting fees.
Ben, je vous entends que c'est pour
I understand that the bill before us seeks to exempt requests made by permanent residents. So the list from A to H is only for permanent residents, is that what I understand? At 304 of C44.
Specifically, A, we currently have, there's what's being added there, we already have the exemption for temporary resident. What's being added is permanent residents.
Okay.
And then we have an exemption for work and study permits already that's legislated. So really the only amendments that we're seeking are related to permanent residents.
OK. Donc, ça répond à ça, Claire.
Okay.
Other questions on that area? Then on go ahead, Mr. Ouellette.
The IRCC, you have an exemption. You had or you still have an exemption for a couple of different categories. You're asking for additional exemptions from the User Fees Act. What difference has the exemption made in those other categories in being more flexible, or how has it helped IRCC?
So the previous exemptions that were sought and that are now enacted in legislation for temporary residents and for citizenship, for temporary residents, it was sought for a fairly similar reason why we're seeking for permanent residents, and it again has to do with the unique nature of our clientele, that they're located internationally, and that we need flexibility in that sense when setting our fees. For citizenship, it was for other reasons, but within the scope of what we are seeking here for permanent residents specifically, it has to do with that flexibility that we need to set our fees.
And so I guess my question is, how has it improved or helped you in accomplishing your work? So it's good to know about flexibility, but in the case of someone who's trying to get service from the Canadian government, how has it enabled you to do your work easier?
Well, what I can speak to is the scope of this and specifically what it will do to help us improve for permanent residents. So for permanent residents who are located...
Yeah, actually, I'm kind of interested in how it helped, because it's good to know. I want to know how it helped you in other categories, because it's going to be an indicator of how it's going to help you in future categories. And
yes.
So if you can, I'd just like to know, did you see an increase in the number of people who applied? Did you see... was there shorter wait times? Things of that nature. I'd like to just understand what was the effect of that legislative change on the ground, and what would the impact be on the ground of this legislative change?
Okay. In setting fees, that's okay. In setting fees, we look at many aspects when we look at our fee structure. And some of those aspects include the cost of providing that service, a private versus public benefit, things like that. So in the case of a temporary resident, when the exemption was granted, how it may have improved is that the portion of the cost that Canadians are subsidizing may have decreased if we increased our fees, for example. Our fees must remain competitive, though, internationally. So when we have a temporary resident fee or a permanent resident fee within the scope of this proposal, we look at international comparisons as well. So that's another factor that's taken into consideration when we set our fees, to make sure that we're remaining competitive with similar countries like the UK, the US, Australia, for example. And that will help us do our work, but also achieve overall objectives.
Bottom line is to give you flexibility.
Yes.
Any other questions?
So you could increase the fees, you could lower them.
Yes, we can decrease or increase based on a full analysis of the fee against several factors.
Okay, we are on NDP, on Amendment NDP 18. Anything further to add on that, Pierre, before we go to a vote?
Oui, juste une question. Donc c'est en
Just a question. It's only under these powers conferred by the law that you have been able to suddenly increase the citizenship fees from $200 to $600. I think that was in 2013-14. In 2014, yes, we increased the citizenship the citizenship grant fee to $530 in 2014. It would be surprising to see a reduction of costs rather than another increase. Sometimes it can be very drastic increases overnight. I wanted to mention this. It's not really a question, it's more of a comment. But many people have talked to me about this who were thinking of becoming Canadians, but because of the prohibitive costs, they had to save for years sometimes if they were a numerous family to pay for their citizenship process, which is about $600 per person.
Of an exemption are still subject to the Financial Administration Act in the sense that our fees cannot, we cannot charge we can't charge more than the cost of providing the service.
Okay, are you looking for a recorded vote on this one, or are we okay in division?
Recorded vote.
Madam Clerk.
Mr. Fergus.
Contre.
Mr. Grewal.
No.
Ms. O'Connell. No. Mr. Ouellet.
Nay.
Mr. Bruson.
No.
Mr. Deltel.
Contre.
Mr. Alves.
Contre.
Mr. Leiper.
No.
Mr. Dussault.
Oui.
The amendment is lost. On clause 304, shall clause 304 carry? On division? On division. Thank you, Ms. Henderson, Ms. Cote, for your appearance. We'll turn to Division Knight Dean, and we have witnesses here from Finance. Proceeds of Crime, Money Laundering, and Terrorism Financing Act, clauses 407 to 441. And I think we're...
No amendments until 442.
Okay. There is, we do have witnesses with us, but there is no amendments on these sections until we get to 442. So is there any discussion, anybody want to raise anything on points 407 to 441, or can we agree on those to be voted as a block? Hearing nothing, shall clauses 407 to 441 carry on division? Agreed? Agreed. Clause 442, there is, First Amendment is NDP 31. Mr. Dussault, your name is on the list here.
Merci. Who came, but we didn't ask question to them. But now turning to one of our last amendment, my last amendment.
Interrupt for a sec, Pierre. We have quickly rolled through the proceeds of crime under money laundering, and now we'll need. So you folks are off the hook. No questions. So we'll now go to the Invest in Canada Act under Division 20, and NDP 31 is the First Amendment under Clause 442.
Bien, merci, Monsieur le Président. Et effectivement, on se tourne à la loi sur.
Thank you, and now we're back onto investing in Canada. Clause 442, page 268. Just give me a bit of time to get to the right page, and I'll be able to explain my amendment. I have two amendments on this subject. The first seeks to change 5 that talks about the mandate of Invest in Canada. It's a new institution that will work to attract investors to Canada. I would like to add sub C. You have A and B, and my amendment would add sub C, which would say, ensure that foreign direct investment in Canada contributes to creating, maintaining and protecting jobs and to promoting labour and environmental laws. So that in this bill, there be a section that states that not all investment is a good one. Sometimes we have investments that may jeopardize our jobs. When we have foreign takeovers of Canadian companies, for example, it is not always positive. It's often positive, but not always. We also want to make sure that when Canada goes abroad to attract foreign investment, we also want to promote our jobs and labour environmental laws. When we try to sell our country to foreign investors, when we tell them to come to Canada, we tell them that here we protect labour and the environment very seriously. We're not simply an open bar where everyone can throw their money around in any way. To also attract investors, it does not necessarily have to be explicitly written in the law, but I think that adding this in the law explicitly would be clearer when we try to attract investors. So we tell them, first and foremost, that if you want to invest in Canada, it's to protect our country, our jobs, labour and the environment. That's non-negotiable if you want to invest in Canada. It's in that lens that my amendment has been proposed to add a paragraph to the Invest in Canada Hub mandate.
Mr. Albas.
Yeah, thank you. I certainly appreciate my colleagues' intentions on this. However, when a FIPA or a Foreign Investment Protection and Promotion Agreement is made, there often are it often outlines some of the concerns that are addressed here. And then the next stage of a free trade agreement, there actually is an environmental assessment as well as an overview on human rights as well as even to dealing with labor laws. One of the reasons why I supported the TPP, and hopefully the government will be able to find Plan B for TPP or whatnot. But I don't think it's like this agency will be promoting Canada's interest abroad. We have established mechanisms that have been time tested. We have FIPAs with large countries. We have FIPAs with small countries, and they are a very good process. And again, free trade happens if both parties benefit. But again, if we're going to be entering a more sophisticated relationship with another country, FIPAs and free trade agreements, I believe, do exactly what the member here is proposing.
Any other discussion? Pierre, and then Mr. Dussault, and then Mr. Deltel.
J'entends bien mon collègue, mais je vois pas la raison.
I hear what my colleague has to say, but I don't know why it shouldn't be enshrined in this bill. Making it clearer isn't a question of the chicken or the egg. One does not preclude the other. When it's made explicit in the law, it can only be good. It would be clearer for those who seek to work with Invest in Canada. I don't see why one would preclude the other.
Deltel, and then Mr. Albas.
Oui, Monsieur le Président, mon collègue pourra.
My colleague will be able to answer to what the MP for Sherbrooke had to say. I would just like to remind this committee that for us, C-44 is not a good bill. In this bill, there are elements that should be debated individually outside of an omnibus bill. Invest in Canada Hub is one of these elements. We Conservatives have no issue with foreign investment in Canada so long as they follow our rules. But what we do not agree with in this approach is the creation once again of another level of structure and more bureaucracy, which would make the process even more burdensome. We trade with the world in a good way for decades. We welcome foreign investment, and we have done so for even centuries. We don't have issues with the premise. But this idea of wanting to create another stage, another creature, another crown corporation, that makes the system even heavier. The government wants to put its hand in the pockets of the free market. Let's allow simply companies to come to Canada, just like Canadians invest abroad. We need to strike the right balance. Let us not forget that when we see our entrepreneurs that invest abroad, when we see our entrepreneurs buying foreign companies for the benefit of Canadians, then we applaud. But we cannot simply have double speech on this front. We cannot be happy when we invest abroad, but be angry when foreigners invest in Canada. We need to strike a balance. And so we will be against all the following clauses, and I ask you to note that we will be asking for recorded votes for every single clause.
Albas.
Yeah, and again, I know where the direction the good member from the NDP is coming from. I think, though, this is in relation to a mistaken understanding in terms of how trade starts. Trade starts to the benefit of both parties, but we're not talking about government to government. We're talking about individual private interest. For example, there are some wineries that before the FIPA with China actually British Columbia wineries went to China. They did not have any protections under any agreement, but because they had wine that Chinese consumers wanted, Chinese buyers wanted, they went on their own risk, and they basically went out there for those new markets. Now, you get that critical mass where enough private interest is happening, but there's friction because there's regulations that are not harmonized. There are questions of legality and protections. If someone wants to start exporting on a regular basis, perhaps they want to start purchasing land in China so that they can distribute their wares. Then there becomes a public interest in seeing investment protected on both sides. So what I would imagine whether it's this model, which I don't necessarily agree with, but again, we have to always bear in mind who will initiate trade will not necessarily be government. I'm hoping that these groups will help facilitate those private interests to be able to build a public interest that now will then the FIPAs and the free trade agreements that deal with all the things that the good member has raised here in terms of environmental standards, human rights, and obviously labor standards. That's the work of government as there is a bigger public interest. So certainly appreciate where the member is coming from, but it's inappropriate to put in the mandate of someone who's going to start putting on the table, rather than saying, how do we get Canadian businesses to connect with consumers and purchasers in this country that we're operating in, to start saying, no, we actually have in our mandate that we first have to start settling laws. And of course, the consumers and the purchasers of those goods are going to say, what? I can't deal with that. I'm not the government. So this is actually an impediment towards those first stage interactions that are initially private. So understand that this gentleman wants to have the public interest observed and these good things happen, but that's the very basis of trade, is those private interests seeing new markets, establishing deals that work to both sides, and then government can come in to sort out and to create stronger ties.
Okay, I remind folks that witnesses are here, Mr. Marcotte, Mr. LeBlanc, and Ms. Pellerin, if there's any questions to them as well. Mr. Ouellette.
Just a question for the chair and for the clerk. Did we, in our letters to other committees, include this? It was a study by another committee. You'll think about that. And,
we'll think about that. I don't think we did on this one.
So we studied this?
Yes, we heard the witnesses on this one. We'll check on the letters, but I don't think we farmed this one out. I think we dealt with it ourselves.
Okay. And I just have
No, we did not farm it out.
No, that's what I thought. Okay.
Okay.
Mr. Ouellette.
Thank you very much. Just a few questions for the witnesses, and I promise I'll be short for my colleagues. But how is the Invest in Canada hub going to be different from the BDC or the EDC?
I'm sorry?
Be different. Comment ça va être différent? How's
the Invest in Canada hub is not going to be a financial institution. It's a promotional entity. So it really is there to attract foreign investors, make the sales pitch, and then the hub can introduce those investors to the Canadian stakeholders such as BDC, EDC, or other departments, agencies, even the provinces and municipalities to complete the value proposition so that the investor makes a decision to choose Canada.
Okay. I was just also wondering, is there an idea about where the Investing Canada Hub will be looking at? Are you going to places like Toronto, or is it going to be spread around the country in places that might not receive a lot of foreign investment, for instance, Saskatchewan, Manitoba?
The headquarters of the
Canada.
organization has not been decided yet. Obviously, one of the key roles of the hub will be to work with provinces and municipalities, and so presumably it could envision having antennas, but these decisions have not been made.
How would this Investing Canada Hub be working with, for instance, Indigenous peoples?
Very interesting. There is interest in Indigenous communities sometimes to attract foreign investment through, for instance, agencies such as the regional development agencies also. There's certainly connections that can be made there. It is part of its mandate to attract investment everywhere in Canada. So it will work with the stakeholders who have an interest in attracting investors and promote their locality to foreign investors.
So you mentioned it was for promotional reasons. I was wondering if you could give an indication about how you're going to go about promoting. And so is it going to be people going on trips overseas, doing ad campaigns overseas, or trade missions? What is actually seen or forecast in how you believe it's going to be working?
Yeah, the details of how it's going to do that are not defined yet. But if you look at the mandate itself of and the role of the agency, it will actually develop an integrated strategy, working with provinces, municipalities, communities to attract foreign investment, and that strategy will include marketing campaigns, promotional campaigns. It could be advertising campaign. That's not been decided. But obviously there would be demarching, working closely with our trade commissioners who are located in the field already to promote Canada as a place to invest.
Which minister will be responsible?
The Minister of International Trade has received a mandate to create the Investing Canada Hub. Officially, the responsible minister will be appointed by Order in Council once the act is enabled.
How would the director and the board of directors be chosen?
Through an order in council and basically following the regular process of OIC appointees.
How will your chief executive officer be chosen?
Same thing, through OIC and through the appointee process led by the Privy Council office.
Will all the general conflict of interest guidelines apply to the chief executive officer?
Will the what guidelines? I'm sorry?
The conflict of interest guidelines apply to the chief executive officer?
Absolutely. As a reporting officer.
Will the Investing Canada Hub have the ability to make loans or give out funds?
No.
Will they be able to invest in corporations that come here?
No.
So it's strictly promotional purposes?
That's right. Facilitation and promotion.
Will the corporation be able then to take, for instance, groups, like we're talking a lot about wine and beer and spirits, will they be able to, for instance, when I was in Taiwan, there was very little or no Canadian beer in Taiwan. Would they be able to, a country of obviously around 23 million, be able to take Canadian microbreweries and wineries, a couple of representatives to Taiwan to promote the greater trade in that area? How would they?
The role of the agency is to attract investments, not so much promote trade abroad. We already have the Trade Commissioner Service doing that. And so it could, for instance, take on missions a municipality, a community, a province, or a series of them to a market to promote their jurisdiction to foreign investors, to attract them to come to Canada, to establish themselves, create jobs, develop a laboratory, a manufacturing facility, a service company, for instance. So the purpose is to attract foreign investors here to create jobs in Canada directly.
Are the so is the Canada Investment Hub are the employees going to be civil servants?
They will be part of the public service, yes.
Okay. Getting back to, sorry, I don't mean to. It's just,
it's your right.
It's
you
very.
You are getting over a little on your 5 minutes per party, though.
Well, we should cut that then.
I have a motion to cut it.
5 minutes.
Point of order, Mr. Dussault.
Can you clarify, did we adopt a motion to limit 5 minutes per clause?
Yes, we did.
And now we're on clause...
But we said we would be flexible.
Okay.
Okay, if you can sum it up fairly quickly.
Sum it up, I guess, it's just, I just want to give, full consideration to the motion here. I don't want something to slip through the cracks. Obviously, I don't think we've talked about this. We've been talking about PBO and Infrastructure Bank, and this is $200-odd million, I believe, 218.
Over 5 years, that includes two things, the creation of the agency, but also strengthening the network of trade commissioners abroad.
Okay, and how many employees do you see that you'll be having?
That's not been decided yet. Obviously, there are considerations in front of the Treasury Board related to the structure of the organization itself.
Is there any other organization within the federal government that carries out similar or related types of work?
Many people in the federal government and in provincial governments are involved or have an impact on the ability of Canada to attract investment. You can think of organizations that offer incentives, for instance, to Canadian companies or foreign companies. You can think also of departments who are more regulatory in nature. So a lot of people have impact on our ability to attract investment, but no one actually coordinates all of this, and that's the purpose of the Invest in Canada Hub, to offer a single window to the investors so that they don't have to go to different places to get answers to their questions.
Will you be helping with regulations in various jurisdictions then? For instance, municipalities or provinces, to enable an investor to actually understand the marketplace?
Advice could be provided, certainly, but it's not a main role of the hub to inform regulatory processes.
Okay, can we hold the any more questions till another clause in this section? We're on the amendment for the NDP 31 at the moment. Is there any further discussion on NDP 31? And I think you asked for a recorded vote on all these clauses. Madam Clerk.
Mr. Fergus.
Contre.
Mr. Grewal.
No.
Ms. O'Connell.
No.
Mr. Ouellet.
No.
Mr. Bruson.
No.
Mr. Deltel.
No.
Mr. Alves.
No.
Mr. Leipert.
No.
Mr. Dussault.
Oui.
NDP 31 lost. NDP 32, Mr. Dussault.
Merci, Monsieur le Président, et voici une chance en or pour les...
This is a golden opportunity. Before I talked about a unique opportunity, but now it's an excellent second chance for the Liberals to add this to their speaking points. We propose, or they could say that they accepted an opposition amendment because it's not controversial at all. As you can see, at clause 442 that we are currently studying, we could add section 24 to this section that seeks to make Invest in Canada Hub an organisation that will have to table a report to the Minister of Finance every single year, to the Minister of Finance, or, well, to the relevant minister that will be designated by the government. I don't know which minister will be given this portfolio. Perhaps it'll be innovation, perhaps it'll be innovation and economic development. This minister will receive the Invest in Canada Hub's report every year, and this will be tabled in Parliament every year. It's a very simple amendment. A report will have to be made to the Minister every year about the institution's activities, as is the case for many institutions that publish reports every year to either Parliament or the Minister. And so naturally, in this institution, it would be a good idea to have a report that would be tabled to discuss what had been done over the previous year, a report that would be available to parliamentarians for study, and also for the general public that would be able to read the report. It's not a very complicated amendment, and so I don't see why my colleagues on the other side would refuse this amendment, where Invest in Canada Hub would do like other institutions do and publish a yearly report about their previous year, a report that would be tabled by Parliament. It's a very sensible proposal. It's similar to what happens with other organizations. I don't know why such an amendment would be refused.
Okay, thank you for your presentation of Mr. Ouellette, but on the point that Mr. Dussault is raising, what is the reporting procedure of the Investment Canada Hub at the moment, as a part of the department, or it's not a separate entity as such, is it? Could you explain that, Mr. Marcotte?
Absolutely, with pleasure. The Invest in Canada will be a departmental corporation. Just like the Canadian Food Inspection Agency, the National Research Council, the Canada Revenue Agency, and as such, it will be subject to the financial management policies of the Treasury Board, which, as part of the estimates documents, call for the creation and the tabling in Parliament by the Treasury Board President of a departmental plan and of a departmental results report. So it is not written in the Act, because it is actually subject to everything else, the same requirements as any departmental corporation with regards to financial management. And so a departmental plan and a departmental results report will be tabled by the Treasury Board President in Parliament every year.
Mr. Ouellette.
So the Invest in Canada Hub will be subject to the Treasury Board's policies on financial management established pursuant to its authority under the Financial Administration Act.
That is right.
Thank you.
Mr. Albas.
So just under Mr. Dussault's amendment here, it talks about the impacts of foreign direct investment, but it actually doesn't say, or any requirement to actually outline what foreign direct investment was done. Now, maybe I'll ask the officials if that's my interpretation, because it's talking about the impacts. It's not actually talking about foreign direct investment.
The impact of foreign investment? Well, obviously, in its report, when it's in its results report, the Hub will state what it has accomplished with the resources that the Parliament has appropriated to it.
Okay.
And will claim success. I mean, that certainly is the objective, to show what it has accomplished and what kind of investment it has attracted, how many jobs these investments have announced to be created, the value of those investments. And so it will report to Parliament through the regular means of other departmental corporations and departments.
Okay, so there will be some reporting on foreign direct investment achieved by the Innovation Hub.
That's right.
Or not?
The Investment
Hub. Pardon.
Yes.
Okay.
Mr. Dussault.
Juste une question de clarification.
Point of precision. Who would be the responsible minister?
En fait,
no, the Minister of International Trade is the minister that would be mandated for this. It's part of their mandate letter, however, for legal reasons. The designated minister will be designated by OIC if Parliament approves of this bill. The minister will be appointed at that time. And so the reports that we're talking about that will be tabled, be they for the next year's priorities or with regards to results, will this be tabled by the President of the Treasury Board? Will that be part of all documents that are submitted by this person for all departments and every single ministerial or departmental agency? And so it might just be one document among hundreds tabled. With my proposal, it would be a separate report tabled by a minister in the House. On the 15th day after receiving the report, my objective was to make this even more accessible to the general public rather than waiting for it to be part of an international trade's results report or a report tabled by the President of the Treasury Board. It allows me to say more about my amendment to differentiate it from general MOs for departmental reports.
Okay, we're all in, all done. All those in favor, NDP 32. Amendment to clause 442.
Recorded vote, please.
Recorded vote. Madam Clerk.
Mr. Fergus.
Contre.
Mr. Graywell.
No.
Ms. O'Connell.
No.
Mr. Ouellet.
No.
Mr. Bruson.
No.
Mr. Deltel.
Contre.
Mr. Albas.
Contre.
Mr. Leipert.
No.
Mr. Dussault.
Oui. Amendment is lost. On shall clause 442 carry, and I believe you asked that these be recorded. And while I'm at it, do you want each? Well, deal with this one first.
442 to 450, please.
442 to 450 as one block on a recorded vote. We're agreed to that? As one block?
We could do that. Yep.
Okay.
On division?
No, recorded vote.
Recorded vote.
Okay, Madam Clerk, clauses 442 to 450.
Mr. Fergus.
Pour.
Mr. Graywell.
Yes.
Ms. O'Connell.
Yes.
Mr. Ouellet.
Yes.
Mr. Bruson.
Yes.
Mr. Deltel.
Contre.
Mr. Albas.
Contre.
Mr. Leipert.
No.
Mr. Dussault.
Oui. That will end that section. Thank you to the witnesses for your presentation and your answering of questions. We'll turn to Division 21, the modernization of service fees, clause 451, and to come forward is some new witnesses. Mr. Ermuth and Ms. Mueller. On clause 451, is there any discussion on the modernization of service fees? Mr. Albas.
Thank you, Mr. Chair. And I just wanted to say thank you to the officials, both that are just leaving and also that have just come on this. We, as the Conservative members on this committee, will be opposing the modernization of service fees. Particularly, I just want to raise out the point. I think it's been well established that while the CPI does offer an attractive, expedient way for the government to basically keep up and pace with inflation, just due to the whole lock-stop variety of different fees and services that are offered, I don't think it's a very good fit. I also do think that it allows for people to not to moderate or to temper their spending to try and keep the services at as low cost as possible. That innovation, that spendthrift, that bootstrapping will just not happen when you have a CPI index, when you don't have a direct correlation between a basket of goods that is for a consumer versus a user fee that is quite different. I also want to just raise some concerns from the Hunting and Angling Caucus that we have, that they feel that the user fees, and then the escalator that's attached to it, will actually discourage people from getting out and enjoying the outdoors, particularly when we talk about everything from licenses to costs for visiting our national parks. And overall, Mr. Chair, we do appreciate that that we do have to make sure our user fees are consistent so that taxpayers are not subsidizing. This one-size-fits-all imposed link, I think first of all, the Joint Standing Committee of the Scrutiny of Regulations will take issue with this, just because you're fixing a price to something that does not match what the actual cost is in delivering the service. I think that will be, because the two are not distinct, that, usually user fees are meant to be self-liquidating. So they either pay for the infrastructure and for the processing and for any work that's done to it, and it's not supposed to make any profit for the government, I think there is going to be some unintended consequences that go along with this policy that overall that we cannot support. That being said, there should be an element of cost recovery. I just do not believe that this is the proper mechanism. I think a rolling 3 to 5 year review to keep these things current will continue to serve Canadians better. That being said, I think we also know that we have 3 voices on this committee, and we will stand opposed to it, but we'll see what the majority of the committee wants to do.
Okay, is there any other discussion? And we did ask, I think the last time you were here, to provide us with information. I believe you did provide us that information, I do believe, come in on the various fees that were being applied under various things. If I remember correctly, I believe that did. We've had so much stuff come in, I'm not exactly sure on this one. In any event, we did want to have the information of what these service fees applied to the various aspects, passports, etc., etc. Mr. Albes.
Yeah, I'm sorry, Mr. Chair. I should have said that the Conservatives, so we've talked about this previously, is that we don't mind if we vote in block for clause 451 to 457.
Okay.
And we would request a recorded vote if there's unanimous consent to proceed in that fashion.
Okay, is there any other questions? Mr. Dussault and then Mr. Ouellette.
Oui, merci, Monsieur le Président, et je remercie nos...
Thank you, Chair. I'd like to thank our friends who came to appear before us today. I believe that some have come back twice, so thanks once again for being here. I will have to speak out against this measure again. We'll be voting against. Just like our Conservative colleagues, we have not been convinced through these consultations and through witness testimony that this was the right option, and that all service fees should be indexed to inflation, and this until the end of time. Yesterday, Chair, you mentioned that sometimes inflation has, during your life, not mine, reached 20%. So perhaps it could happen once again. Such inflation could happen again.
Inflation was around 10 or 11, but interest rates were 22.
Les taux d'intérêt qui affectent l'inflation étaient...
So interest rates that can affect inflation were very high. And so inflation can still be relatively substantial. To link service fees to inflation is not the right option, especially with such an infinite time frame. There may have been other ways to reach this objective, to make sure that taxpayers don't pay unduly for services that are rendered to other taxpayers. We want a fair system. I don't believe that this measure is the right one to reach this objective. I will therefore be going against 451 to 457.
Any further discussion? Mr. Ouellette.
Just a few short questions. So in consultations under Section 12, the responsible authority must consult interested persons or organizations. So how are there organizations that haven't done that for a while in the federal government?
Are there organizations? Sorry, I couldn't hear the...
Are there organizations, departments that haven't done the consultation in a long time on certain fees?
So they would not have done consultation in terms of fees, but they would be in regular contact with their stakeholders on the services that they're delivering on other aspects of their business.
Okay, and how do you constitute some of these advisory boards or on the fee structure?
The advisory board, that in terms of within the legislation?
Yeah.
So the advisory board within the legislation, again, if there's you're talking in terms of if there's a dispute that's unresolved?
Perhaps, or just how do you actually do the fee structure?
So the fee structure, again, the idea would be is that the proposal would be that first of all, there'd be a consultation with stakeholders. If issues are not resolved, then there would be the ability to appeal in terms of having a panel struck, in terms of the panel The idea would be is that the department, the organization, the government would appoint one person to the panel. The stakeholders who are still opposed to whatever is the aspect of the proposal that's where there's no agreement would appoint a third person, and then combine the two members of that committee would then appoint a third person, and from that then they would have a review of the issue and issue their report.
So fees could conceivably go down?
Fees could conceivably go down under the legislation, yes. In terms of out of the process in terms of whether the costs go down, et cetera, fees could go down at any point, but that wouldn't, I mean, there'd be discussion with the stakeholders, but it would not be the same level of consultation as if there was a fee increase.
Mr. Ouellette, that it? I do have one question. It's a very serious one on user or service fees. It was reported in Blacklock's just recently, and I'll read it. An Access to Information memo says federal agencies have simply ignored a 2004 law requiring transparency in user fees. The bill was, at the time, was passed by a colleague of mine, Roy Cullen. It was Bill C-212. It passed the House of Commons 13 years ago and had unanimous support. The Act required public notice of new changes, appointment of an independent panel to field complaints, and a requirement that departments disclose actual costs of government services offered at a fee with performance standards and annual reporting to Parliament. 2016 Treasury Board memo obtained through Access to Information disclosed 84% of government fees are never reported, and a quarter of departments, 10 out of 41, sought exemptions from the Act. And so my question is, and maybe you're not the one that can answer it, but given the fact that we got escalators in service fees and excise taxes, my question is, why has the Act passed 13 years ago not been followed? If you don't have the answer, then I'm asking you to get one.
Sure. So in terms of your question, and forgive me, I'm not familiar with the specifics of the piece of the media that you're reading, but the statistic, the 84%, it's not necessarily that they're not reported, because we actually, through the departmental performance reports, have a number of fees that are reported. I think what from our understanding is 84% of the fees are not subject to the User Fee Act. So with the passing of the User Fee Act, which was a private member's bill, subsequent Department of Justice interpretation came to the conclusion that unless a fee was amended or introduced after the introduction of the User Fee Act, that it was not subject to the actual provisions of the User Fee Act. One of the things we are proposing, and with the Service Fees Act, we think is a significant improvement, is the fact that with the definition that we've worked on in conjunction with our DOJ, Department of Justice colleagues, all fees that fall within the definition will be subject not to the new legislation. So we will have the full coverage where all of the provisions of the Act would then apply.
Okay, if you could, I do have one more question coming from Mr. Ouellette, but if you could, if you need the article, I can get it for you. I assume somebody has seen that article. If you could give the committee a written response on that, I'm sure Mr. Cullen, who's a former colleague of mine, will be asking from his perspective why the law wasn't abided by. And we will need to get a response to him, and certainly this committee would like a response on that. Mr. Ouellette.
I was just interested in what you had said before. So, Mr. Ermith, you had suggested that everyone was complying in evaluating the user fees, and here I learned that it's 84% that are not complying. So what would be the truth then? Is everyone complying, or is everyone not complying?
So again, forgive me if I misstated. So right now, under the current User Fee Act, we have greater than 80% of the fees that are not subject to the provisions of the User Fee Act, again, as a result of that Department of Justice interpretation. That doesn't mean in terms of the reporting, which we have, well, $3.5 billion worth of costs reported on through departmental performance reports, that departments are not following certain aspects, including the reporting associated with the legislation. So I guess the point is those that are subject to it are, to the best of our knowledge, following the legislation, but the bulk of them are not actually subject to the provisions under the under the current User Fee Act.
It's a strange situation, isn't it?
Strange, many things strange happens in government. Okay. Any further discussions on clauses, I believe, were 451 to 457. We get unanimous consent to vote on as a block. Is there any further questions on any of those sections? All those in favor by a recorded vote, 451 to 457. Madam Clerk.
Mr. Fergus.
Cool.
Mr. Graywell.
Yes.
Ms. O'Connell. Yes. Mr. Ouellet.
Yes.
Mr. Long.
Yes.
Mr. Deltel.
No.
Mr. Albas.
No.
Mr. Leipert.
No.
Mr. Dussault.
No.
Carried.
The schedules.
And these are deemed moved already, right?
Yeah, so you just have to ask the question.
In Bill C-44, Schedule 1 shall thank you to Mr. Muth and Ms. Mueller, and you can get back to us on that information if you could. Thank you. Shall the Schedule 1 carry? On division. Shall Schedule 2 carry? On division. On the short title, shall Clause 1 carry? On division, shall the title carry? On division, shall the bill carry? On division?
We should vote again.
Okay, recorded vote on this one, Madam Clerk.
Mr. Fergus.
Shall the bill carry?
Just be cool.
Mr. Graywell.
Yes.
Ms. O'Connell. Yes. Mr. Ouellet.
Unqualified, yes.
Mr. Long.
Yes.
Mr. Deltel.
No.
Mr. Albas.
Qualified, no.
Mr. Leipert.
No.
Mr. Dussault.
Carried. Shall I report the bill as amended to the House?
Chair, before we move on to the last question that you're going to ask us, yesterday at testimony, when we were considering the Liberal Amendment number 6, which was regarding what would be the ability of individual members or senators to seek from the Parliamentary Budget Officer a study on whatever matter relating to the federal government, I had asked the witnesses about how would that provision provide individual members of the House or of the Senate to ask any questions that they wish for the PBO to consider. And the response, perhaps the witnesses did not, maybe my question wasn't clear, or the witnesses didn't understand the question, but the response was no. Subsequent to that, at the end of the testimony, I had a conversation with the witnesses, and they indeed clarified that with the amendment, that in fact individual members and senators would have the opportunity to propose to the PBO a course of study. I would appreciate it if it's possible if the clerk would seek a short written confirmation of that from the witness, so that we could read that onto the record. I think it's important for all members to feel reassured that as members they would have that ability, and that was the purpose of the amendment that was being proposed.
So what you're basically asking is that we get a written response to that question. People in agreement with that?
Fine.
It would clarify what members and senators can do in terms of what requests can be made to the PBO. Mr. Albas.
Yeah, just before we finish the process today, and this may not win me many friends today, however, I've been through different processes for BIAs, sometimes as a substitute member in both the previous government and obviously here in this Parliament. And I have to say that I'm very surprised that many government members did not make very much comment, if at all, on their own BIA, particularly when you had a number of amendments come up. Again, I'm just raising that because, you know, if you really do feel that the legislation is strong and whatnot, I got to say Mr. Ouellette was asking many questions for clarification. I think that that's definitely a good thing. I don't know, but maybe I'd ask Mr. Long, as the de facto leader of this group, to maybe, you know, work with them, you know, because ultimately we can't just simply have it where one or two viewpoints is represented. The Canadians expect that if a bill is coming forward, that the Liberals are not just simply going to let you know, the government have their way with things. That there should be you know, a spirited defense on the policies that youth feel is important. Because if you're voting for something, then you should be able to defend it too. And maybe I'm out of place for saying that, but I do think it should be on the record that I have not seen that.
Last 10 years in government, when one man ran the entire show.
I'm going to rule yet order. Mr. We've order. We've got. We're down to 2 clauses left. Mr. Dussault.
Thank you, Mr. Chair.
Graywell, Mr. Dussault.
I may not make friends here, saying that I want to thank all the parties who have proposed amendments, substantive amendments, and constructive proposals to the bill, which is the Green Party, the Bloc Québécois, the NDP, the Liberals. So I want to thank them for these very good proposals to at least try to amend and improve the bill.
What point was it?
Then we have Mr. Ouellette, and we haven't voted on, shall I report the bill as amended to the House as yet? We get 2 more votes to do. Mr. Ouellette.
I just want to say thanks to the researchers, the analysts, and the clerks for your hard work. And the people, the interpreters, and the lady who does the microphone, as well as the food service personnel. It's very much appreciated, and the people who put the name tags. It was a fun experience.
I think that comment is unanimous. Agreed. Thank you for that, and thank you as well to all the folks who've helped out in getting this far. Now, we have a motion before us. Shall I report the bill as amended to the House? Agreed. And shall the committee order a reprint of the bill? Agreed. Carried. And with that, thank you all. Okay, tomorrow we will meet at the regular time, 3:30 to 5:30. It'll be committee business, planning of future business, and upcoming parliamentary pre-budget consultations. So people need to think about what weeks we should do that, what the schedule is, and we're not sure of the location as yet, are we? We think we're here, but look at the notice, and I guess my question is, I expect that meeting people will want it in public. We usually do, or should it be, is there parts of it in camera?
I think it should be in camera.
Should be in camera? Okay, then for tomorrow's meeting we will be in camera. Then this meeting is adjourned, and we'll see you tomorrow at 3:30. Meeting adjourned.